In this case, I will be filing also additional affidavit in connection with the case. Also, I have taken consent of the other side. Also. This matter will be taken after 1 week. Also.
You are appealing for whom?
I am for the respondent.
Number 2.
Lordship.
Mr. A. Ahmed, the learned counsel, appealing for respondent number 2, submits that he is going to file an additional affidavit in the incident case, and he has already taken the consent of the other side. Consent of the other side for examination of the matter. Is the matter be listed
After a week.
after the
Obliged.
Wait, please, Your Lordship. I beg to mention item number 44.
Huh?
Item number 44.
40. Yes.
My lord, as per the office note, my lord, the service is not complete, my lord. Service is not complete, my lord. We have taken steps on 18/5/25 26. So the service is not complete.
You are Mr.
Bijdet Talukdar.
Huh?
Bijdet Talukdar.
Mr. B.J. Taluda, the learned counsel, submits the service in the incident case is yet to be completed. It pays for adjournment of the matter for 3 weeks. Adjournment of the matter, let the matter be listed after a week. After a week.
May I please, Your
Yes.
Lordship, my lord, in connection, my lord, item number 22, my lord, one additional affidavit has been filed, my lord, kindly, it may be. One additional affidavit has been filed in connection with item number 22, my lord. So it,
Why you are filing additional affidavit?
my lord, bringing some, my lord, additional document.
What?
My lord, as cross case was, my lord, filed, so that has been registered, my lord, against, my lord, informant.
Okay.
Obliged.
Item number 16, my lord. There is some mistake in annexing the documents, my lord. As I pray before your lordship, that I may be allowed to withdraw the petition.
Okay. You are Mr.
M. Pandit.
So M. Pandit. M.
M. Pandit.
Your name is not there.
Yes, I am for A. Lal.
Mr. M. Pandit, the learned counsel, appearing for Mr. A. Lal submits that he has instructions to withdraw the instance. Prayer is allowed, prayer is allowed, matter is dismissed as withdrawn.
May it please your lordship. Also, in item number 29, the case diary is not yet received.
29.
29.
Hmm.
There is also an
Proceed.
interim order. Separate for extension.
Is there not received in the instant case? Interim order. So fast and self-contained is the next letter list. When do you want it? 17th. 17th.
It comes up. Agree.
Can't it be liquid earlier? 11th.
Naturally.
May I please, Your Lordship? I'd like to mention item number 36, Lordship. CD and postmortem report is not received, Lordship. CD and postmortem report is not received, Lordship.
CD not.
Sorted may be given, Lordship. This is third time. Sorted may be given.
CD not
Postmortem report.
CD not received. Let the matter be listed.
CD and PM report, Lordship.
CD and PM report not received. Let the matter be listed on
Sorted may be third time, Lordship.
10th of
Obliged.
May I please, Your Lordship? Your Lordship, I beg to mention an item for listing, 2019 matter, Your Lordship.
You go to the senior banks. Senior banks is there.
It's a compensation of land matter.
Compensation of land.
Yes.
This is not a, this is a criminal bank.
Bench 4.
May I please, Lordship? I beg to mention item number 41, Lordship. CD not received. Interim is there, Lordship. Shall we continue?
41, Mr. Swami. CD not received. CD not received. Interim order so past address and continue with the next step of this. The matter will be listed on 10th of June.
Obliged.
May please, sir. I beg to mention item 39 of today's list, Your Lordship. I have the instruction to withdraw this on Your Lordship.
And your name?
F. Hussain, Your Lordship.
Of course, in the learned counsel, appealing for the petitioner submits the civils instructions to withdraw the instances. And it may be dismissed as withdrawn.
The interim order may be vacated.
Interim order so past address stands vacated.
Obliged, Your Lordship.
May I please, Your Lordship, 4860 application. 483. I was arrested on 15/5. There is a section 69 and 81. But to my humble service, a big FIR, your lordship might have read it, will not justify because she was the consenting party, but now she is saying that wrong identification was given and out of fear I have physical relation. Other two sections are bailable. This is from Gauhati.
Okay, heard this, I see dismissed the learned counsel appealing for the accused applicant. So Mr. Show me the learned to be for the state, is in application on section 40 of BNS 2015 for granting bail to the accused applicant. In connection with all, PS case number 2026 under section 69. 115 in bracket 2, stroke 151, stroke 351, in bracket 3 of BNS arising out of FI, stop it, BNS. The FIR relates, FIR to 13/2026, 25/26 relates to Ali's rape committed by the accused on the informed person. All for the case guidance, later listed on
Is in Gauhati, my lord.
9th of the
9th, you said this was 9th. 9th, here's the matter list.
Please, 483 application also arrested on 13/5/26. Basic allegation also find at page 17. He wrote some obscene things and took some pasted some photographs and threw in their front of their house. That is the basic allegation. That too on 15/11/25. And the FIR was filed on 1/3/2026.
15/11,
15/11/25. The incident occurred.
FIR,
15/11/2025.
FIR lost.
FIR on 1/3/2026. This year. So, and there was no explanation of delay also. Basic allegation the lawsuit will find. He wrote various obscene things against me, distorted and pasted my photographs and threw them in front of my parents' house at Patidarang, my married daughter's house, in front of our house. That is the basic allegation. Page 17, middle portion. And she is a married lady, lordship. At one point of time, we had also had some affairs. So that is basically. And daughter is also married. Only 2 sections are non-bailable, rest are all bailable.
Sorry, will give a short date.
From Sipajar.
Sipaja. Lord Mr. D. Development and Senior Counsel assisted by Mr. Counsel for the accused applicant. Also, for the state. This is an application on the for paying for the bail of the bail to the accused applicant in connection with Sipaja case case number 36 of 26 registered under sections 127 bracket 2 stroke 75 stroke 76 351 in bracket 2 stroke 29 before stroke 9.
Monday, next Monday.
Yes. Full stop.
Shivasani.
The full days will have case.
Very good.
Case relates to an FIR dated from 2026 lodged by the informant. Alleged accused applicant is certain option mechanism for the courthouse. The call for the CD with the matter will be listed on 8th of June.
March.
Made previous Your Lordship, 483 application, Your Lordship. The petitioner is arrested on 25, 2026, Your Lordship. FIR is on page 9. Lordship, the informant is known to the petitioner, Your Lordship. The informant is the photographer of his wedding of the petitioner. His wedding was solemnized long back in 2022, but the informant has not given him the photographs and the videos of his marriage. And 30,000 advance is also given by the petitioner to the informant. And whenever I asked for the photos and the videos, he used to say that the photo get deleted and he is trying to retrace it out. So and he's getting it deleted since 2022, and he is not even returning the money. Your Lordship, whenever he used to go to his house, he used to flee away. On that day, Your Lordship, where he found him in the traffic point, and in the heat of the moment, the altercation took place and the incident happened, Your Lordship. Lordship knows the emotion behind these photographs and videos of a marriage, Your Lordship. He is not giving it. Since 2022. Your
So,
Lordship.
Yes, Lordship. Injury part was there, Lordship, taking assaulting by a knife, Lordship. That part,
All-
injury part was there, Lordship. That's why injury report is required. Very short type of case, there may be called for at this stage.
you will give us short Lordship.
Hajo, Your Lordship.
Hard. MS.
Hussain, Your Lordship.
Send the letter council. Also to people submit and then we from state. This is an application. In the section 483 of the NSS. For paying for the banking base in connection with alia questions based on 173/2026. Under section 1152 in the data. Then 1182. So 2042 of BNS 2052. Added section 1 given in of BNS. The case relates to assault by the accused, assault by the accused applicant on the informed. Is the related case there also? Also the case there is.
8-6.
8. Oblige, Your Lordship.
Made clear, Lordship. FIR, Your Lordship will find page 16, Lordship. Here the petitioner made some comments, Lordship, and because of that one FIR was lost and he is in custody, Lordship. Page 16 is the FIR. May I read, Lordship?
Call for the city.
Here, Lordship, that one thing, Lordship, may kindly consider that specific no allegation is there, Lordship, and otherwise also.
We see, I've gone through the pair, I've heard Mr. Ahmed Balane consulting for the accused, and also heard Mr. Petition, for the state. Raise an application under the civil of the system. Bail to the accused applicant in connection with Sunnah is number 14/26 and this is 1/6 bracket 1 bracket small a stroke 299 stroke 351 in stroke 352 stroke 351 in bracket 1 stroke 49 stroke 61 in bracket 2 VNS.
8 or 9.
And FI was lost. Yes, by the comment commenting. Like use of. FI dated
FIR dated 12/5/2026.
by the informant releasing the accused applicant spreading provocative video, provocative and abused video to the society against the vice chairman of Sudan Municipal Board and concerned president of once funded developments. Call for us to be with the matter it on 11. 11.
Obliged.
May I please your lordship. Regular bail application, lordship. Lordship, a subsequent second application, lordship. Lordship, earlier one was withdrawn, lordship. On page number 55, lordship, the earlier order. Lordship, matter pertains to recovery of commercial quantity of cough syrup, lordship, from the position of the co-accused, lordship. Charge-sheeted matter, lordship. 299 days as of today, lordship, behind the bar, lordship.
What was the quantity commercial?
Commercial quantity 3,000 bottles was recovered from one co-accused, namely Biswajit Saha, lordship.
1,000 boxes.
3,000 bottles of Iscaf, lordship. The substance is codeine, lordship.
PCR. Okay, heard Mr. D. Mehdi, the learned counsel, appearing for the accused applicant, also heard Mr. Mr. Deepak Swami, the learned AP for the state. This is an application number 483 of BNSS 2023. Paying for granting of paying for the accused applicant. In connection with NDPS case number 11/2026 arising out of courtship, police of courtship case number 235/2025 in the section 22 in bracket C of NDPS Act. And FI was lost. Releasing. FI was lost. When is the FI filed?
Lordship,
FI dated
FIR is dated, lordship, on 5/8/2025, lordship.
5/25, releasing 2,000 bottles. Codeine syrup. Illegally recovered from the co-accused of the accused applicant. Charge in the instant case is already been filed. Raised to the call for the PCR in connection with any case file registered?
Lordship, NDPS case is registered, lordship.
Huh?
NDPS case is registered, NDPS 11/26.
In connection with raised to the call for the PCR in connection with the NDPS case number 11/2026 pending before the court of
Special judge NDPS, lordship.
special judge NDPS
Kamrup Metro.
Kamrup Metro. Did the matter be listed on? June 11.
Deeply obliged.
May I please your lordship, the allegation of pickpocketer, lordship, due to his previous record, lordship, he was picked up by the police. Then after the FIR date, lordship, is on 8/5/2026, lordship, that on page 10, and he was arrested on 21/5, lordship, after 12 days, 12 to 13 days.
Let's see what is there in this. But Mr. S. Muni, the learned counsel, appearing for the accused applicant, also this is an application on the section 483 of BNSS paying for granting bail to the accused applicant in connection with valid for case number 178/2026 registered under section 112/307/61 in bracket 2 BNS 2023. And a fire was lost on 8/30. Leasing. Leasing. Peak of an amount of basically 1,900 from the stuff. All for the city, with the material fixed 9th of June.
Much obliged. Here, whatever lordship, the FIR lordship, the lordship will find on page 10. The three friend lordship, they have made a conspiracy lordship, loot lordship 20 lakhs, 66,000 lordship from the office collection. Lordship. Thereafter, whatever 3% were arrested on the same date. The main person and the other person, other 2 persons were arrested. The person lordship, the one Farooq Yunus lordship, from whose possession that entire amount lordship 20 lakhs has been recovered. He was already been released on bail by this honorable court lordship. Now he's already 45 days lordship. The entire amount was recovered, only 66,000 has not been recovered lordship. It is the amount was 20 lakhs, 66,000 lordship.
He's already in jail for?
Lordship already released lordship.
No, I mean, this accused.
45 days lordship. Same forwarding report, same date of arrest, lordship, all the three accused persons.
So you are Ritudas.
I am Ritudas lordship, from his possession, the entire amount was recovered, the person who was granted bail. Copy it. You have to go to 39 days or 42 days duration. It is order of college.
Mr. Goswami, 45 days already, I mean, the main accused, the money recovered, let him go.
I think it's a matter related to financial misappropriation.
3 lakhs already received, recovered, that, I mean, the 45 days already passed. And the co-accused already granted bail. So though, these are sufficient grounds. Heard Mr. S. Mulu, the learned counsel, the praised the accused applicant. Also heard Mr. B. Krishnan, the learned applicant for the state. This is an application under section 483 of the BNSS. Bail for granting bail to the accused applicant. In connection with Alpha case was number 58 stroke 17 stroke 229 in bracket 2 stroke 318 in the first 14 stroke 312 in bracket 2 stroke 309 in the 61 in bracket 2 BNSP. And FI was lost on 10/4 to 19/4/2006. Alleging a conspiracy to misappropriate an amount of rupees 20 lakhs 66,600 by one GIZ case agent along with 2 other persons, including the accused applicant. In terms of the conspiracy. How the money was stolen?
It is a conspiracy lordship. He the person
Conspiracy after it, what happened?
after he lost the FIR lordship that Farooq Ahmed.
Money was
Mofidul lordship himself lost the FIR of robbery Thereafter investigation, it came to light that they have made the conspiracy.
One of the accused person.
He's the employee of that company.
One of the accused person that is the GIG case
Lordship, he was the employee and he was sub collector.
had in fact filed a fire, blazing a robbery. However, later on it was found that the robbery was hatched and conspired by the accused applicant along with the accused. Anyway, accordingly, the aforesaid Gauhati PS case number 50/2026 was registered and investigated, and during the investigation, the accused applicant was arrested by the police and he is behind the bars for last 45 days. Learned counsel, Mr. S. Muni, the learned counsel, appealing for the accused applicant, submits that the main accused in the instant case, namely Mr. Mofidul Islam, who was the GIG case agent, has already had been arrested and has already been granted bail by a coordinate bench of this court. He submits that the money involved has already been recovered, and taking into account the long custody of the accused applicant should be granted bail at this phase. The learned APP, Mr. Goswami, however, opposes the bail, submitting that the investigation of the case is yet to be completed. Taking into account the fact that the accused applicant is already behind the bars for last 45 days. 40 is, and the money has 45 days, money involved has already been recovered, and the main co-accused has already been granted by bail by coordinate bench of this court by this by 2026. This court is also of the considered view that further custodial detention of the accused applicant may not be required in the instant case. Accordingly, it is directed that the accused applicant shall be released on bail on furnishing of a bail bond of rupees 50,000 with the security of life amount in the satisfaction of the learned CJM Gwalpara, subject to the following conditions: that the accused applicant shall not directly or indirectly make any inducement, trade or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or any police officer. The accused applicant shall cooperate with the investigation and make himself available to the investigating authority as and when called for. That the accused applicant shall not leave the jurisdiction of the CGM without prior permission of the court of the opposite court. Next paragraph, in terms of the opposite direction, the instant bail application is disposed of.
Lordship, on small, the earlier case, Lordship was supposed to be on 9, Lordship. Can it be on 10, Lordship, if possible?
And
10 plots. Much obliged, your Lordship. Much obliged. Sign number.
May it please, Lordship. 482 application, my lord. The acquisition is that, my lord, the accused number 2 has stolen 4 numbers of ceiling fan and 1 battery from a masjid, my lord. Thereafter, articles were recovered from the custody of the accused number 2, my lord. May I read the vernacular at page 17, my lord?
you are accused number 1,
I'm accused number 1, my lord.
and it has been recovered from accused number 2.
2, my lord.
And where is accused number 3?
Accused number 3 is now in absent in my lord, and 2 has been arrested.
Who has been arrested?
Arrested, my lord.
He's inside the custody.
May I read the FIR, my lord?
Page 19 will clarify everything.
Hmm?
Page 19.
Page 19 is the forwarding of the accused number 2, my lord. He was forwarded, my lord.
উক্ত 2 নম্বৰ আসামী আগে পাছেও এনেধৰণৰ চুৰি কৰিছিল বাবে আমি সমূহ গাঁৱৰ ৰাইজে 2 নং আসামী সন্দেহ কৰি ফুটফুচ কৰাত 2 নং আসামীয়ে চুৰি কৰাৰ কথা স্বীকাৰ কৰি কয় যে উক্ত চুৰি হোৱা বস্তুখিনি 1 নং আসামী ঘৰত ৰাখি থৈছে। পিছত আমি সমূহ গাঁৱৰ ৰাইজে মিলি 1 নং আসামীৰ লগত লৈ তাৰ কথা মতে 2 নম্বৰ আসামীৰ ঘৰত গৈ দেখো যে আমাৰ মছজিদৰ পৰা চুৰি হোৱা বস্তুখিনিৰ লগতে খালী গেছৰ চিলিণ্ডাৰ দুটাও উদ্ধাৰ কৰোঁ। পিছত 2 নং আসামীক বস্তু সহ আৰক্ষীক চন্দা দিওঁ। বৰ্তমান 1 আৰু 3 নং আসামী পলাতক অৱস্থাত
Heard,
আছে।
Mr.
টিকে ভূঞা।
PK Bhuya, the learned counsel representing for the accused applicant, also heard Mr. B. Sharma, the learned deputy for the state, raises an application under section 482 of the USS to be for paying for here is paying to the accused applicant, namely Wafiqul Islam, in connection with Lahori Bhattiyas case number 41/2026, registered under section 305 in bracket 3/3/1 bracket 4/317 bracket 4/3 bracket 5 of BNS 2023. The gist of the case as narrated in the FIR bracket 11/4/2026, accused applicant along with 2 other persons have stolen 4 numbers of ceiling fans and 1 mic battery from Ayasa Jame Masjid from a South Chenimari and stored them in the house of accused number 1. That is the accused applicant. Full stop. On the basis of the aforesaid affair, an investigation was conducted, and during the investigation, the stolen articles have been recovered from the house of accused number 2, that is name
Muqtadul Islam.
Muqtadul Islam. Next paragraph. The learned counsel appearing for the accused applicant submits that the accused that the stolen goods have already been recovered from investigation from the instant case is already been completed. We have custody pension for the accused applicant may not be necessary in the instant case, and therefore it pays for bail of the accused applicant in the instant case post. The learned APP on the other hand, Mr. B. Suman, learned APP on the other hand, submits that the investigation is yet to be completed in the instant case, and therefore he opposes the bail of this case to stop. Having gone through the appeals for this court, and after hearing the submission of the counsel appearing for the respective parties, this court is able to recommend that further custody tension of the accused applicant in the instant case may not be necessary. And then to stop in view of the opposite, it is directed that in the event of the arrest of the accused applicant by the arresting authority in connection with the Hollywood police case number 41/2026, the accused applicant shall be released on bail on furnishing of a bail bond of rupees 30,000 with a penalty of life amount to the satisfaction of the arresting authority, subject to the condition that number 1, the accused applicant shall present himself before the investigating authority within a period of 10 days of passing of the instant order. Full stop. Next paragraph. The accused applicant shall cooperate with the investigation and make himself available before the investigating authority as and when called for. Full stop. Next, that the accused applicant shall not directly or indirectly make any inducement from a place or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the investigating authority or any other police officer. Also, in terms of the aforesaid direction, the instant the application is disposed of.
Okay.
Yes, my lord, the petitioner seeking transit anticipatory bail, my lord. In connection with the case, my lord, of Rohtak, Haryana. My lord, a notice was served to the petitioner. Actually, the notice was received by his father. That is page 8, my lord. And he was asked to appear before the Rohtak police, my lord, on 18/5. But he come to know, he has come to know about the notice on 17/5, so he could not comply, my lord. And accordingly, as we,
He's come to know on 17.
my lord, he was at Tezpur, my lord. He is a labor, daily work, labor, my lord. He was at Tezpur.
What was the accusation?
Acquisition, my lord, under, my lord, it's a cyber crime, mainly cheating and, my lord, forgery section is there.
What is this order? Please, 11.
Similar order, my lord, I have annexed one order of this honorable court, my lord.
I mean,
Similar.
I mean, relating to same FIR.
No, my lord, it says, my lord, transit anticipatory bail order, my lord. In similar cases, my lord, this court has granted interim transit bail, that is case 14, my lord, relevant portion. It was granted for a limited period so that he can approach the jurisdictional court seeking appropriate relief.
Okay, there is no issue regarding transit bail. Lordship.
So how much days they will require?
Lordship, first, Lordship, he has to satisfy, Lordship, because transit bail is granted only in exceptional circumstances, as per the judgment also, Lordship. Lordship is well aware. Now, if Lordship is keen to give him the transit bail, Lordship, 10 days, Lordship.
10 days.
10 days, because he has not satisfactorily explained, Lordship, why the delay.
10 days, my lord.
You heard Mr.
M. Ali.
M. Ali, the learned counsel, appearing to the accused applicant. Mr. One, the learned APT for this case. This is an application of the section 450 of the UNS paying for granting transit anticipatory to the accused applicant in connection with PS fiber fine in the section of Haryana. Case number 26/2026 in the section 318/4 stroke 336 in the 338 stroke 340 in the 4 stroke 61 in the code of ENS. The learned counsel appearing for the accused applicant submits that is the accused applicant is a daily wage laborer. And his father has received a notice under section 35 in bracket 3 of BNSS dated 10/5/2026 issued by the police station issued by the police officer of the police station cybercrime Rohtak, Haryana in connection with PS cybercrime bracket Rohtak, Haryana in bracket case number 26/2026, under section 318 336 in bracket 3 338 340 bracket 2 61 bracket 2 of PNS, whereby the applicant had been asked to appear on 18/5/2026 at 11 AM the police station Rohtak. He submits that since the accused applicant was walking in Yazpur, and he was not present when the notice was received by his father. He could not appear before the police station cybercrime Rohtak, Haryana on 18/5/2026. As he got to know, continuation, as he got to know about the notice only on 17/5/2026. Since he has received the notice and he is seriously apprehending his arrest. He has filed this instant application for transit anticipation so that he can approach to the concerned jurisdiction and file the necessary anticipatory bail before the jurisdictional court. He submits that he is not aware of any allegations of any allegations that have been made in the FIR or whether his name has been included in the FIR or not. But he submits that from the notice it transpires that he has been requested by the aforesaid police station of Gauhati for investigation in the matter. The learned Mr. B. Sharma, the learned faculty, submits that forensic anticipatory bail can be granted only on special circumstances and that for a limited period of time to only to facilitate the accused applicant to do the needful for getting the appropriate anticipatory bail from the jurisdiction court. That's all, Mr. Sharma.
Yes.
Okay. Taking into account the process missions and after perusal of the notice, they can 10/5/2026. This court is of the opinion that the apprehension of the accused applicant cannot be ruled out this case, and therefore, mm, taking into account the settled law as laid down in the case of Ista Atul Settlebar and another versus state of Maharashtra and others by the High Court of Judication of Mumbai, of Bombay, High Court of Judication at Bombay, in connection with anticipatory bail application number 14 of 2014. We tried it on 51/1/2014. This court result of the considered opinion that the transit bail can be granted in respect of a case registered under the jurisdiction of another court, another high court, in exercise of powers under section 438 CRPC. Okay, 38 CRPC. Corresponding to 482, no? Corresponding to 482 of the instances. In the second instance. The aforesaid principle has been also uh, uh, also approved by the Honorable Supreme Court of India in various cases. In the aforesaid case of Ista Atul settled by Supra, Supra, the Honorable Supreme Court has observed as follows, bracketed. The matter relates to grant of implicitly paid under section 438 of the Code of Criminal Procedure. The Bombay High Court by input for the dated 31st January 2014 allowed the petitioners to move before their court in Gujarat for said relief and granted transit bail for 4 weeks so as to enable the petitioner approach before the appropriate court in Gujarat. Having heard the learned counsel for the petitioners, we are not inclined to interfere with the interim order. Next one. However, taking into consideration the nature of the case and submission made on behalf of the petitioners, we extend the transit bail in favor of the petitioner up to 31st March 2014, so as to enable the petitioner to approach the appropriate court in Gujarat. If such petition is filed, the appropriate court in Gujarat will consider the same independent without being influenced by any observation made by the Bombay High Court. The question of law about jurisdiction of High Court is kept open. The special leave petition stands disposed of for full complete. In view of the aforesaid discussions and observations of the Honorable Supreme Court, this court is of the considered opinion that that a relief of interim bail under section 482 of VNSS can be granted to the accused applicant with a direction to the accused applicant to go before the appropriate court having jurisdiction for seeking appropriate relief. Accordingly, in the interim, it is directed that in the interim and in the event of the petitioner in the event of arrest of the petitioner in connection with the PS cybercrime in bracket Rohtak, Haryana, bracket complete is number 26/2026. The 26. The accused applicant shall be released on transit bail on executing on furnishing a bail bond of rupees 50,000. with a security of like amount to the satisfaction of the arresting authority. However, it is made clear that this protection is granted only for 10 days of passing of this order. That is up to today's up to 10th of June.
10 days will be on 11th.
10 days will be on first, second, third.
Today is first of June.
Okay, 11. Okay, 11 from the date of the until what is up to 11th 10 to 11 6 2026. So is to enable the accused applicant to approach the competent court for appropriate relief. In terms of the opposite direction, the instant petition, instant ABA application is disposed of.
Obliged.
May I please? So this PRS bail application FIR page 9, Lordship. Case there may be called for that 64 is there.
What is there?
Rape, Lordship,
Rape.
64, Lordship.
The bail was rejected at page 14
That was rejected by an court below, Lordship.
after going to the victims 182 section. So Lordship calls for the civil.
FIR file when 27/7/3/2026. Okay, right, Mr. Heard Mr. So the learned counsel whose applicant also heard Mr. One and APB for the state. This is an application under section 42 of PMSS 2023 to grant 3 years bail to the accused applicant in connection with Makia PS case number 26/2026 under section 231. Bracket 4, stroke 64, bracket 1 of BNS. The FIR dated 27/3/2026 leads to LA's commission of rape by the accused applicant on the informed. All for the case diary. All for the case diary. When do you want it?
11.
Fixed on 16th of June.
May I please Lordship? Lordship, this is an anticipatory bail application. FIR is on page 11.
What is the offense?
Lordship, there are allegation is that the accused persons, they went to a marketplace. They had an altercation with the complaint hearing. But actually, these two parties, they have a long-standing land dispute between themselves. And two of the accused persons, they have also filed one complaint before the executive magistrate. That is also pending. And two of the accused persons, number.
We'll see. I heard Mr. So and counsel appearing for the accused applicant also heard Mr. B. Sharma having appeal for the state. This is an application under section 482 of BNS 203. Paying for granting anticipatory bail to the accused applicants in connection with Pathakandi PS case number 236/2025 registered under section 191 in bracket 3/190/118 bracket 2/117 bracket 2/303 bracket 2/109/324 bracket 4 of the BNS 2023. The allegations in the FIR dated FIR dated
2510,
25
2510.
and 2025 relates to relates to relates to causing grievous causing serious and grievous injuries on the applicant on the informant by the accused applicant's footstep. Call for the case diary.
Two accused persons already granted bail.
Call for the case diary. Let the matter be listed on 9th of June.
Published.
From C.
11th June. 11th.
11.
11th.
Published.
That please allow that. But pre-arrest bail application, your lordship. FIR at page 8, your lordship. 8 is the FIR, your lordship.
Is it?
Page 8.
What is
My lord, the matrimonial dispute, your lordship. Matrimonial dispute, your lordship. After 13 years of conjugal life, your lordship.
Only serious statement because allegations are very serious to me. Pouring diesel in the body of the victim and then setting her on fire. All these allegations are there.
That is that, my lord, the victim tried to commit suicide, your lordship.
You can see from the case that
In presence of 10 years old son, your lordship. He tried to commit suicide due to mental distress.
I heard me, sir.
Yeah, my lord, one thing, my lord, except, at least, my lord, except this number 1, others may be protected, your lordship. Others,
Who are others?
my lord, petitioner.
Father.
Mother.
Father and mother.
Father not alive. Mother is petitioner number
Mother
2.
and
Mother and elder sister and brother-in-law. Main allegation is against petitioner number 1, case number
but
1.
they have instigations now. We'll see. We'll give a short date. I mean, if nothing is there, all will be granted bail.
We
Don't worry.
will appear before the investigation.
Don't worry. Wait for some time. Heard Mr. So-and-so, and counsel again for the accused applicant also heard Mr. B. Accused applicant, sir, also heard Mr. B. Sharma, the already appeal for the state. This is an application under section 483 of BNS, 482 of BNS, for granting clearance bail, the accused applicants in connection with Nubri PS case number 163, section 61, stroke 55, stroke 117, bracket 2, stroke 1019, bracket 1, stroke 3, bracket 5, BNS. Uh, the allegations as narrated in the FIR relates to relates to the allegations as narrated in the FIR is that the sister of the informant who was married to the accused applicant, number 1, accused applicant number 1 was set on fire by the accused applicant number 1 on instigation of the other accused applicants. Call for the case diary. Let them be strong.
from Thubri, from Thubri.
If we anticipate the bail, let us give them on 11th of June.
Bless you.
May it please your lordship. Lordship, this is anticipatory bail application. FIR is at page number 13. Allegation, lordship, is basically, lordship, establishing physical relationship on the pretext of marriage. Page number 13 is the FIR, my lord.
How old are you?
25 minor. The alleged victim is 20. And lordship admitted position is, I'm 25,
20.
she is 20. And lordship admitted position is that lordship, we are in a relationship. There is objection from both the sides. Therefore, lordship, marriage could not be solemnized. And lordship, so far as section 69 is concerned, lordship, there are two parts. One is employing deceitful means, and another is false promise. My humble submission is that lordship, my promise was not false. Even lordship, the petitioner is still ready to marry the alleged victim. My lord, may I pray for interim lordship so that lordship, I can participate.
What is other people?
Other people, lordship, brother, and other family members, lordship, because of the last three lines. The accused person leaving me at the house, and the
Accused
other
person is one person is Munaf Ali and other person.
other persons, lordship, two is Sanwar. Only one petitioner is here,
The
lordship.
two is who? Sanwar is who?
Sanwar is brother.
And it is Rina Khatun.
Rina Khatun is mother. Sister, sorry, lordship.
They are not.
Page numbers, they are not before your lordship.
At page 22, lordship, bail was rejected.
Hmm?
Bail rejection order is at page 22 after perusal of the case. That's the repeal. Observation is at page 23.
Mr. Sharma, I am allowing this.
Lordship,
But Mr.
I'm Ahmed.
I am Ahmed, the learned counsel appearing for the accused applicant. So far, this is Sharma, and I make a for the state. This is an application under section 482 of PMSS to be quickly paying for 3 years paid to the accused applicant in connection with Golofganj police fixed number 91 registered under section 969/351 in bracket of the BNSS. And FIR was lost by the informant on what is the date FIR?
Page number 14.
Date, you tell me date.
20/04/2026.
Releasing that the accused applicant on many occasions established physical relationship with her on the pretext of marriage. It was contended, it was also alleged in the FIR that with the false promise of marriage, the informant was invited on many occasions to the house of the accused applicant, and they are committed the sexual, then established physical relationship with her. It was alleged that after such commissions on many occasions, with the instigation of his family members, the accused applicant right away. Accused applicant threatened and tortured and avoided the marriage. It also understood that there were certain incidents of blackmail by using private photographs, photos and videos also. Learning concept of paying for the accused applicant, so means that the accused applicant in fact wanted to marry her and had a serious relationship with her. However, due to the objections of the respective families, he could not marry. So means that though they had physical relations on a couple of occasions. That is consensual in nature and not forceful. Therefore, the service that was very for a submit that the accused applicant shall cooperate with the investigation in the event of this release from pre-arrest. Procedures that will take place in force of taking into account that leads to before this court and the reasons where this court is support is so that opinion so that this is wherein anticipatory wherein the privilege of anticipatory can be granted to the accused applicant. Therefore, is directed that in the event of his arrest, in the event of his arrest, in connection with the local police station case number 91/6, accused applicant shall be released on bail on furnishing of the bail bond of rupees 50,000 with the signature of like nature to the satisfaction of the arresting authority. Arresting authority subject to the following conditions. The accused applicant shall appear before the investigating officer within a period of 10 days of passing of this order. Then the accused applicant shall cooperate with the investigation and make himself available as and when called for. Then the accused applicant shall not come directly or indirectly make any use or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the investigating officer. In terms of requisite directions, there is every application is displayed.
Alia, class.
Then yes, the FIR has not been registered now, field date lordship, but the police has been searching the petitioner. The fact of the case is that the petitioner and one girl, namely in para 6, I have explained lordship, on Lokhi Prasad, both aged 28 years. They were in lovely relationship lordship.
Both
And-
is it? Both is it? Is it?
Aged 28 years.
Is
The
it?
petitioner as well as the Lokhi Prasad, the girl, the para 6, I have mentioned lordship. Both aged 28 years. They were in lovely relationship lordship, and the family members, both the family members have insisted they got their marriage registered, and accordingly, as because there was delay of registering the marriage, the girl has filed a complaint before the Bhangagar PS lordship a few days back, and thereafter they have entered into an declaration. The petitioner has made a declaration that he will got the marriage registered. Then he applied for the marriage registration lordship. That is last page number 15. That is the acknowledgement lordship. Already applied lordship. But what happened? Due to some documentary, during verification for lack of some documents, the voter ID card, the same has been rejected as reported by the girl itself. So the boy wanted some time to get a duplicate of his voter ID card, and he will complete the process of registration. And for that matter, the dispute arose, some differences arose between them. And on the instigation of the family member of the girl, she has been complaining the matter before the police. And initially, we do not know who are the police. Therefore, we had we had stated about the Bhangagar police as well as Bhorlumukh police, as because her residence is at Bhorlumukh, and all women police. Report called for. Now we came to know that Bhangagar police has been searching him. That's it. So the report may be called for from Bhangagar police station, and interim protection from coercive measure may be passed. Because he is also going to settle the matter as early as possible. This is the marriage application, this acknowledgement online. It
This is only the acknowledgement.
Yes, Lordship, because it is online uploaded, Lordship. It is the only,
Which page 15 is your application of a receipt acknowledgement.
yes, Lordship.
It was done on when? 2019?
19, Lordship.
26. And when 19?
This declaration was made on 13, Lordship. There's page 13. The type copy is page 13, Lordship.
13 is what?
13 to 26. That he said that within 3 months they will enter into marriage, and then within 3 months they have already submitted all documents, both of them, photographs, Aadhaar card, PAN card, etc. Lordship.
Mr. Sharma,
Lordship,
what is to be done?
story is something else, Lordship.
Hmm?
Story is something else. It is not before us now, Lordship.
Of course.
Okay, we'll get that report since they.
From Bangalore police station, he's saying that Bangalore police
Yes.
station.
Till then, Lordship, forcing measure may not be taken, but action may be there.
Okay, heard Mr. D. Ullah Melane counsel appearing for the accused applicant, appearing for the applicant. Also heard Mr. B. Sharma, the Learned APB for ST. The instant application under section 482 of BNSS 2023 has been filed praying for granting PRS bail to the accused applicant who is apprehending arrest in connection with a case in connection with a case the details of which are not available with the accused applicant at this stage. Full stop. Mr. Ullah, the learned counsel, appearing for the petition, accused applicant submits that though the details of the case that is the details of the FIR that has been lost before before the police station is not available with the accused applicant. However, from the activities of the police, it is presumed that the case has been filed before the Bangalore police station. Is it so?
Yes, Lord.
Bangalore police station. First,
On the
the learned counsel appearing for the police.
Lokhi Prasad.
Huh?
The informant may be Lokhi Prasad, the victim, the girl.
That will be coming. The learned counsel appearing for the accused applicant further submits that police has been searching. The Bangalore police has been searching for him, searching him on the basis of the FIR that has been lodged by one Lokhi Prasad, MS Lokhi Prasad. MS Lokhi Prasad. Full stop. He submits that the accused applicant and the aforesaid informant were in a relationship for the last 5 years and they were about to marry each other. Full stop. However, certain differences arose between them, and due to that, both of them, in fact, approached the Bangalore police station to lodge complaint against each other. But the same was not lodged due to a settlement to the effect that the accused applicant will marry the aforesaid informant within a period of three months. Accordingly, the accused applicant has applied for registration of marriage, and the same was accepted by the concerned department, that is Revenue and Register Management Department, by an acknowledgement slip with acknowledgement number RTPS MRG stroke 2026 stroke 5001163 dated 19/5/2026. He submits that though the application was submitted and it was acknowledged by the concerned department, the same was rejected due to non-filing of certain essential documents. Also, correct? Essential documents. In view of the aforesaid, the accused applicant is required to file the application anew.
Yes,
Application anew along with the essential documents. However, the informant, rather than waiting for some more time, filed the complaint against the accused applicant before the Bangalore police station.
Yes.
In view of the aforesaid, the accused applicant is seriously apprehending arrest and has filed this application for certain protection. Full stop. The learned KPP, Mr. B. Sharma, the learned KPP, has fairly submitted that a report from the Bangalore police station can be sought for in the instant case. Taking into account the report's submissions made by the respective counsel appearing for the parties, this court is of the opinion that till the time a report is submitted by the Bangalore police station in connection, Bangalore police station in connection with any complaint filed against the accused applicant, that is Narayan Rai, no coercive action should be taken by the by the police authorities. It is directed that Bangalore police station shall submit a report in connection with any complaint filed by the informant MS Lucky Prasad against the accused applicant, that is Narayan Rai, within a period of how much time did it take?
Friday also you can get
Huh?
it. Even by Friday you can get it.
For Friday. By the next date fixed, that is on
Fifth.
5th of June. Let them write fixed on 5th of June.
Obliged.
Maybe it's like, we have given under section 483 of BNSS. Lordship, the informed lost the FIR before the pneumatic yes, stating that some materials are stolen from the construction site, and the accused person are caught red-handed by the local public.
Stealing what?
Rods, some rods
The rods from where?
from the construction site. Of the
Construction site.
Yes, Lordship. Thereafter,
So you have been arrested.
no, Lordship.
Why? Others
My
have been
name is
arrested.
not Vivek.
So you were a smart person. You have
No, Lordship.
evaded the arrest
Lordship,
in spite of
no, Lordship.
huh?
FIR is page 11 type करके Kamal Gupta,
Also will kindly peruse page 17. That should be very clear.
He's 17.
17, forwarding report of the three accused person who has already been arrested.
Okay.
Lordship. My name is not in the FIR, Your Lordship. And the stolen articles are already recovered, and as per instruction, the stolen articles has been handed over to the informant for use.
A lot of dacoities and stealing is happening in Gauhati. What is this? Heard, Mr.
Lordship,
Heard, Mr.
is
Your name?
Ahmed. Is Ahmed.
Eh?
Is Ahmed.
Oh, sorry.
You kindly maybe given
Ahmed, the learned-
interim protection.
the accused
The
applicant.
petitioner ready to appear before
B.
the
Sharma,
IO.
the learned APP for the state. This is an application on this. Extension 482. 483 BNS.
Lordship,
Here is being the accused applicant in connection with the PS case number 73/2026 under sections 303 in bracket 2 stroke 112 bracket 2 of BNS 2023 2023 full stop. Matter was lost
on 5/5/2026.
2025 25 Amazing. Amazing stealing of bundles of roads, lots and bundle of roads from the house of the accused, house of the accused. Some, it was alleged that some of the accused persons were caught red-handed. Red-handed. All for the city. Let the case be fixed on. Let the case be fixed on. 11.
Maybe in tempo.
11.
May I please, your lordship? My lordship, I am head teacher of Jantipur High School, the inspector of schools, Kamruk Rural. My lordship, on 25/5/2026, my lordship, I have been called to the police outpost, my lordship, of police outpost of Burha outpost under Sipajar PS, my lordship. There was a
Tell me the allegation.
My
that
lord,
happened.
my lord,
Come on,
there was a
what has happened?
matrimonial dispute, my lord, between me and my wife, my lordship. She left the house on in February, my lordship. So police informed me that she alleged some.
I mean,
but I could not.
there's no FIR, nothing.
No, my lordship. But
Where is your apprehension?
but my lordship, police has been calling me repeatedly to go there. I have stated in Para, my lordship, on
Which are the phone numbers by which?
my lordship, page 9 and.
Which are the phone numbers that they have called?
My lordship, that thing I have not that I'll submit my lordship on the but I am in real apprehension because I am teacher, my lordship, of head teacher, my lordship, and it is only matrimonial dispute, my lordship. There are 9, my lordship. I have stated, my lordship. There are 9. I have stated. There are 8 and 9, my lordship.
So you are aware where the case is filed. Why do I need to get the FIR?
My lordship, as per my information, my lord, FIR was not registered. Inquiry is being going on, my lordship. But as because I have been, I am.
Participate in the inquiry.
My lord, I'll participate, my lord, because I am head teacher, my lordship, and there is matrimonial dispute, my lordship. I am in apprehension of arrest, my lordship.
Mr. Sharma,
Lordship.
let him go. Interim, let him go. Then we'll see we'll call for a record. I mean, report. Because he has been called to the police station.
Yes.
It seems, and like he has been inquired, and there was some matrimonial dispute is going on. If there are some legal notices and all these things, we'll see what it is and a teacher.
They have made the wife number 2.
The notice has to go. Notice has to go. I mean, but in interim, we'll no coercive action. Heard, Mr.
SB Lashkar.
Mr. Lashkar, the running counsel, appearing for the accused applicant, also heard Mr. B. Sharma, the running APV for the state, This is an application under section 482 of the NSS 2023, praying for granting clearance bail to the accused applicant. Accused applicant who is apprehending arrest. Arrest due to an alleged complaint made before Burha outpost under Sikwaja police station, Eastern Dora, South Coast. The learned counsel appearing for the petitioner, accused applicant, submits that though he has sufficient information that a complaint has been filed by the informant, that is respondent number 2, against him, the same may not have been lodged at this stage, and he could not procure any details of the aforesaid complaint in spite of his best efforts. Also, he submits that the accused applicant was called to the police station on 25/5/2026 by the police authorities, and the police authorities have been constantly calling him over the phone. He submits that the informant and the accused applicant were married for
marriage on 1911.
married for last 3 years, and certain disputes arose between the accused applicant and the informant. And thereafter, the informant left his house, started staying separately. In view of the aforesaid, therefore, then he submits that the accused applicant had made an effort to bring her home by issuing a legal notice. However, she did not return to his house, and the efforts of resolving the dispute resolving the aforesaid matrimonial dispute between the parties are still going on. He submits that, however, since the police is looking for him and looking for him, he is apprehending arrest, and therefore filed the instant application. Submission for the state has submitted that since no FIR has been lodged as yet as submitted by the learned counsel appearing for the petitioner, a report from the concerned police station can be called for. Taking into account the submissions made by the respective counsel appearing for the respective parties, it is directed that the OC, officer in charge of Burha outpost. Burha outpost is within which police station?
Sipajar.
Sipajar. The officer in charge of Sipajar police station shall submit a report in connection with the instant case concerning the accused applicant, namely Afazul Hussain. Afazul Hussain within the next date list, by the next date listed. Full stop. It is also directed that in the meantime, till the next date, no coercive action shall be taken on the accused applicant by the police authorities. Let the matter be listed on 5th. Oh, it will do. 5th. Let the matter if he takes on 5th.
Highly obliged, my lord.
I'll just come back in 5 minutes. The last case, issue notice also to respondent number 2. I use speed post. Last case, no? Issue notice to respondent number 2 by way speed post. Skips. Mr. Sharma, the other case notice has to also go for respondent number 2.
That's it.
Last case. It will.
Oh, yes, notice has to go.
Notice has to go by speed post. Because it's not, it's not a boxer case. So, no, by speed post, steps to be taken within 3 days, huh?
Can Lordship, get the date be given on 10th or 11th, Lordship?
10 or 11. Who was the counsel? Counsel is left, huh? Anybody knows the counsel? What was his name?
SB Lordship. SB Lordship.
Hmm.
Yes, yes, he will, for the certificate copy. He will have to be apply for the certificate copy, then we will come to know. So,
Or else we can issue notice that on the next date. We'll issue notice in the next day because it's coming on 5th only. Let us see the report.
Lordship,
Should come. Miriam, not paper.
May it please your lordship.
Yes.
Lordship, this is a regular bail application, lordship, 35 days in jail custody, lordship.
How many days?
35 days in jail custody, lordship.
Hmm.
Punishment is 7 years, lordship. Statutory period is 60, lordship. Here, FIR, lordship, will find on page 15 the vernacular, lordship.
CD has not been received, Lordship.
He has
Girl already been recovered, lordship. Girl recovered, handed over to her parents, lordship.
Okay, let the CD come. Heard Mr. B. Chaudhary, Learning Counsel, appearing for the accused applicant. Also heard Mr. B. Sharma, Learning APP for the state. CD in the instant case is yet to be received. Let the matter be listed on. When do you want it?
It's from Satyabadi, lordship, Nolbari.
Well-
Borpeta, lordship.
12, Lordship.
It's from Borpeta, lordship, Satyabadi.
12. Okay, 12 also.
Oblast.
May I please, Lord, sir. Charge seated case, my lord. Lordship will find FIR at page, it starts from 10, my lord. Relevant is at page 14, my lord.
Page
14, my lord. 1 Here, my lord, sir, fake currencies were recovered and 3 persons were arrested, my lord.
including you.
Yes, my lord. 2 petitioners are there, my lord. One has already been released on bail. That your lordship will find at page 46, my lord. The coordinate bench has granted.
What is your name?
My lord, my name is Wangnang Mofuk and Yamke Nampu
From which place?
from Arunachal Pradesh, my lord. Khunsa, my lord. Nearby the police station. See, they are from Khunsa, my lord. Arunachal Pradesh.
Onsa.
Khunsa, my lord.
So why you have come here?
Because case was registered, my lord, at Dibrugarh, my lord. District, my lord, Dibrugarh, PS Jaipur, my lord. Case is registered here, my lord. 24 number of bundles of fake currencies were recovered, my lord. And there are 11 witnesses are there, my lord. Out of these, 4 witnesses have already been examined, my lord. And last witness were turned up, my lord, on 22nd of January, my lord. After that, my lord, no witness has come, my lord. 22nd of January, 2026, my lord. On that day, my lord, 4 witnesses were examined and cross-examined, my lord.
How many witnesses are there?
11, my lord.
And already examined?
4, my lord. Only on one date, my lord, on 22/1/2026, my lord, 4 witnesses were examined, my lord. After that, my lord, no witness has been turned up, my lord. Last date was fixed on 26/5/2026, my lord. On that also, no witness has turned up. And next date is fixed on 6/6/2026, my lord.
6, I think that they will examine all these 7 witnesses.
Till last 6 months, my lord.
So
no-
it is going on in a very speedy way.
For last 5 months, my lord, no witness has been turned up, my lord. And co-accused has already been granted bail, my lord, page 46, my lord.
We're gonna define putting it. Co-accused is totally on a different. Lordship, kindly see the observation at page 48. Page 48, paragraph number 7.
My lord, they are behind the bar for the last 321 days, my lord. On any condition, my lord, they may be allowed to go on bail, my lord. And one is lady, my lord.
Lordship, this relates to fake currency. Lordship, the conviction is many years. Lordship. Imprisonment for life, Lordship. Paragraph 7, Lordship is
Paragraph?
paragraph 7 at page 48. The co-accused was granted bail. He was on a different footing, Lordship. He was only the driver of the vehicle. And these two are the passengers from where, Lordship, the fake currency were recovered. Lordship has kindly see. There does exist the possibility that the petitioner, who was not in conscious possession of the recovered fake currency, and the driver of the hired vehicle is generally not expected to know the contents of the luggage of the passengers, which facts no doubt can only be determined during trial. However, keeping in view above, as well as period of detention 200 days, he was granted bail. And Lordship, from here, seizure, Lordship, is from the conscious possession of these two petitioners, Lordship.
And they are behind the bars for how many days?
321 days, my lord.
321
days.
They were arrested on 16/7/25.
Yes, my lord.
And Lordship, charges were framed on 12/12/25.
In the TCR, my lord, you'll find it page 47, my lord. At page 47, my lord, notice is there, my lord, 48. Notice is there, my lord. They have not intimated to the family members of the petitioners, my lord. Only one WT message was sent, my lord, on, they have arrested on 15/7, my lord, and it was sent on 16/7/2025, my lord. But it was home sent, it has not been given anything, my lord. At page 47, my lord, in TCR, my lord.
That ground has not been taken in the bail petition, Lordship.
Because we have also come from the record, my lord, after going for the records, my lord.
Lordship, may I draw Lordship's attention to page 45 for a moment.
45 of
40,
SRE.
no, bail petition, Lordship. This is the Lordship rejection order. I am inviting your Lordships to paragraph number 4. This is the observation of the court, Lordship. Page 45. Yes, paragraph number 4, Lordship. I have considered the materials on record. The case has already reached the stage of evidence and the accusations are of serious nature. The earlier rejection and the present stage of trial weighed against the grant of bail. The accused are stated to be resident outside the jurisdiction, which raises concern regarding their availability during trial. At this stage, release of the accused may prejudice the proceeding. In these circumstances, I am not inclined grant to bail. Now, Lordship, paragraph 5, Lordship. While disposing the bail petition, this court takes note that prosecution is strictly directed to call its witness on all fixed dates. Today, no witnesses are present. Learned PP submit that the complainant is a public servant and due to election, he could not appear in court. So, Lordship, the court is ensuring, Lordship, that the trial is
No,
progressed
well,
as-
no, they are not appearing, my lord. On 26/5, they also not turned up, my lord. And then again, it has been fixed, my lord, 6/6, my lord.
Even then, Lordship, there is no delay. As of
321,
now,
and my lord, it is not far from the Jaipur and the Onsa is not far, my lord. It is only 50 kilometers. No, this is the border area, my lord. Arunachal and Assam, my lord. So it is not far.
No, the distance is not a matter at all. Distance is not matter at all. We'll have to see the what is going on in
Only
Arunachal,
they
what
are
is going
resident of
on
the
going
Arunachal, my
in
lord.
Assam, what is going on in Mizoram, what is going on in. I mean, you'll have to see that.
Because, my lord, in
Distance
any
is-
strict condition, my lord,
Distance is not a matter.
it is only in any strict condition, my lord.
then apart from that, Lordship, regarding the merits of the case, Lordship, these 4 PWs that have been examined, they have clearly implicated. I am inviting Lordship only to PW3.
No, I've gone through.
Yes, they have identified, they have said, Lordship, the seizure. And Lordship, there are 2 more seizure witnesses that are yet to be examined.
Okay, heard Mr. S.K. Poddar.
Hey, how are you, my lord?
Huh?
Hey, how are you?
A. Hawari, the learned counsel appearing for the accused applicant, also heard Mr. B. Sharma, the learned APP for the state. The instant petition under section 483 of BNSS filed by the accused applicants, namely Ngang Mofuk and Wamke Namfu have been filed for paying bail in connection with Sessions case number 229/2025 under section 61(2)(3)(5), 112(2)(3)(5), 179/3(5), 180/3(5), and 318 in bracket capital C (3)(5) of BNS 2023 pending before the learned additional district and session judge Dibrugarh corresponding to Jaipur PS case number 37/2025. The accused applicants were arrested on 16/7/2025, whereas the charge sheet in the instant case has already been filed on 12/2025. 4 witnesses out of 11 witnesses have already been examined before the trial court. And the next date fixed for examination of witnesses have been examination of witnesses is on 6/6/2026. Full stop. The gist of the case, as has been narrated in the FIR, is that one SI Assist Mahanta of Jaipur Police Station on 16/7/2025 lodged an FIR before the officer in charge of Jaipur Police Station, stating that Inaka was placed on 15/7/2025 and And during the Naka checking at 5:30 p.m., one white color Mahindra Bolero vehicle bearing registration number AS06 AJ 7874 coming from Naharkutia side towards Hukanjuri, the said vehicle was stopped at Naka checking. It was alleged that 3 persons, including the accused applicants, were in the vehicle, which was driven by one Santosh Roy.
Yes, ma'am.
One Santosh Roy. So driver along with 2 people.
Yes, ma'am.
During the checking, police allegedly recovered a plastic packet inside a black colored leather bag, containing 24 numbers of bundle of Indian currencies. On opening of the plastic packet and examination of the same, the currencies were found to be fake ones. And each denomination in one bundle was found to have the same serial numbers. Accordingly, the police seized the fake Indian currency notes along with a mobile handset, other cards, etc., from the position of the accused persons. Inside the vehicle. The accused persons found inside the vehicle. Full stop. Next paragraph. Accordingly, the case was registered by Jaipur Police Station case number 37/2025, corresponding to GR number 18/2025 under section 61 in bracket 2 stroke 112 in bracket 2, 179 stroke 180 and 318 in bracket 3 stroke 3 bracket 5 of BNS. Full stop. After the investigation, the police filed a charge sheet against the accused applicants. Full stop. It was found that the vehicle was hired by the accused applicants and the same was driven by the driver, that is Santosh Roy. Full stop. It is seen that the aforesaid driver has already been granted bail by a coordinate bench of this court by its order 5/2026. Full stop. The learned counsel appearing for the accused applicant submits that since 321 days, the accused applicants are behind the bars, and the trial has proceeded for last 4 months, nothing has happened in the trial. And after examination of 4 witnesses, no more witnesses could be examined by the prosecution till date. He submits that taking into account the long custody of the accused applicants should be granted bail at this stage. He submits that in the event of granting bail to the accused applicants will cooperate with the trial and shall be present before the trial as and when required. Mr. B. Sharma, the learned APB, on the other hand, submits that the trial is going on at a reasonably good speed and it is expected that the trial will be concluded soon. Full stop. He further submits that the case involves recovery of huge number of fake Indian currency, having a bearing in the economic status of the country. Full stop. He submits that the accused applicants are resident of neighboring Arunachal Pradesh, and in the event of their release, there are every possibilities of their influencing the trial by not appearing before the trial court, as well as by influencing any witnesses, if any, Therefore, he submits that at this stage, the accused applicants should not be granted bail, full stop. The TCR in the instant case has been produced before this court, and the same has been produced minutely by this court, full stop. This court has also heard the submissions made by the counsel appearing for respective parties, full stop. It is seen from the records that already 4 witnesses have been examined out of 11 witnesses, full stop. And the next date is fixed on 6/6/2026, which is a few days after today, full stop. This is also seen from the records of the trial court that there are sufficient incriminating materials against the accused applicants, pointing fingers to them about their prima facie involvement in the alleged offense that has been narrated in the FIR, full stop. Taking into account all the aspects and the facts in entirety, this court is not inclined to grant any bail to the accused applicants at this stage. In view of the aforesaid, the instant bail application is rejected. Easier to be sent back to the
Yeah, please, your lordship. 483 application lordship. Case has already been submitted. And lordship will find the FIR at page 14.
page 14, yes.
Particular page at 17. Eighty days behind the bar mark.
Yes, then how
And
many days?
annexures, my lord,
How
and
many days?
80 days behind the bar.
Hmm.
And my lord, annexure 6, that is the order of the Sessions Court,
Hmm.
Tezpur, my lord.
Hmm.
The bail was rejected,
Hmm.
and same day charge was paid
Hmm.
under section 376(2) NN 417.
Hmm.
My lord, that bail was rejected by the Sessions Court
Hmm.
on 8/4/2026. My lord, warrant was issued against him on 23/12/2025, annexure 3.
8/4/2026, you were there.
No. 8/4/2006, bail was rejected, my lord.
8/4/2026, you were there before the court or not?
Yes, I am there in the court.
Hmm. Then what happened?
Then, my lord, warrant was issued by the
Warrant was issued earlier.
earlier, my lord.
Hmm.
Based on the warrant, that bail was filed, and accordingly, that bail was rejected.
Hmm.
On the very date, my lord,
Hmm.
prior to that date, my lord, I met an accident, my lord, bike accident, where I got severely injured, my lord.
Hmm.
And annexure,
So you were granted bail earlier?
no, my lord.
No.
No, my lord.
So okay, you were awaiting arrest.
Yes, my lord.
You were awaiting
No,
arrest.
no. I am not aware of the pendency of this case. Someone were issued, that is reflected on the record, my lord.
Hmm.
I was not aware of this case.
Hmm.
And accordingly, when I come to know that one case is pending before the Honorable Sessions Court, Honorable CGM Court, I have appeared through a learned
You
counsel.
were arrested when? When you appeared?
11/3.
11/3.
Yes,
Where is 11/3?
11/3, annexure 4, my lord. Page 29.
The strength of warrant he was arrested.
Thank you.
So what is your ground?
So I made an accident, my lord, prior to that day, my lord.
Accident about the offense you tell
Yes,
me.
yes, my lord. Now,
Offense you tell me.
my lord.
You made it an
now-
accident, committing certain things that is not
No, my lord,
something great to be told to the court.
my lord,
You say something great things to the court.
my lord, petitioner wife is now pregnant, my lord.
Hmm?
As per the record,
Is
my
it
lord.
required to be pregnant?
Yes, my lord.
Huh?
Page
Is it
35.
required? After you exploit a woman, is it required to be?
No.
Required somebody
Petitioner,
pregnant? Impregnate?
not a case of 376, my lord. Petitioner is already married, my lord.
Hmm.
And the woman who lost the FIR, she is also a woman,
Hmm.
married woman, my lord. Petitioner is already a married man, my lord.
This court is not saying he's a male. He's a married woman only. We are aware of this.
My lord, petitioner original wife is there, my lord. And now she is pregnant. I am not talking about that earlier who lost the FIR.
So now, what do you have to say?
Lordship, informant is a married lady. There is no doubt, Lordship. In the FIR it is stated. Only thing, Lordship, FIR was lost in the year 2019.
FIR was lost in 2019.
Yes. Charge sheet was submitted in the year 23. Under 366, Lordship, IPC. Thereafter, Lordship, he was absconding during the investigation. Subsequently, notices were issued, summons was issued. He did not appear, and thereafter, Lordship, on the strength of warrant, he was arrested. Now, Lordship, in the case, already 3 PWs have been examined.
Yes.
And all of are hostile witnesses, to be frank, and altogether 5 more witnesses are there. 8 witnesses are there. The victim has not yet been examined. That is the status. And Lordship, interestingly, the victim's 164 statement was not recorded. She did not appear before the concerned court, Lordship, in spite of police asking her to record her statement. Only her 161 statement is there. I have flag mark in the scan copy. It's nothing is very difficult to read.
My lord, FIR itself reveals that there is no ingredients of 366 and 376. She went with him.
Only thing, Lordship, she is a merit informant.
The only thing concerning is like whether his conduct was good or not.
Yes.
Only thing, the only that is that,
Yes.
but now,
The-
now you have stated that how many of the people have been examined? Three.
Three.
Three. They all they become hostile.
Yes.
And FIR was filed on 2019.
19.
Charge sheeted on 2023.
23. 23. Charges were framed on 8/4/26. That was only because of his non-appearance, Lordship. Otherwise, there is an undue delay in the case, Lordship, only because of his conduct. That part is apparently there.
My lord,
Yes, leave it to Lordship.
my lord, Annexure 7, my lord. Annexure 7, page 33, my lord.
Now charges has been framed 417 and 376 2. Within bracket N.
376 to
Within
Within
bracket
bracket
N.
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 And 417.
yeah, this is- How 376 will come in?
For her 161, Lordship.
The FIR.
Yes.
FIR is very clear that she went voluntarily.
Yes.
Yes.
She went voluntarily. Only thing is that false
Cheating part.
cheating part maybe.
Yes.
But 376, I don't think it's in this case.
Anyway, Lordship. Lordship can ensure he participated in the trial, Lordship.
So we'll do that. But like if you do not participate earlier and NBW was issued, the same will happen to you.
My lord,
Then your case, you will damage your own case.
my lord, my lord.
You heard, Mister?
I'll regularly appear.
Huh? Your name?
MP Bora, my lord,
MP Bora.
my lord.
Heard Mr. MP Bora, the learned counsel appearing for the accuser. Also heard Mr. B. Sharma, the learned AP for the state. This is an application of section 483 of BNSS 2023. Praying for granting bill the accused applicant in connection with sessions case number 105/2026 under section 417/376 in bracket 2 in bracket small n of Indian Penal Code in connection with corresponding to Tezpur Police Station. Case number 2467
Public 90.
2019. 2019. Okay, we'll stop. An FIR was lodged on 27/2019 by the informant raising inter alia that she was married to one Farnooz Ahmed, and he introduced him to the accused applicant. Full stop. Semicolon. That after some time, the informant and the accused applicant developed a romantic relationship. And thereafter, she eloped with him as he promised to marry her, that the accused applicant, following the customs and rituals, Hindu customs and rituals, by putting vermilion on her forehead, allegedly married her, and they started living together for 3 days in a hotel. Semicolon, that on 24/7/2019, she was requested by the accused applicant to bring her divorce papers from the previous husband so that he can marry her. Semicolon, however, after her return from Jorhat, she tried to contact the accused applicant, but she found that her number had already been blocked. Her number had been blocked by the accused applicant, and whereabouts of the accused applicant could not be found by the informant. Semicolon, that it was also that the accused applicant had taken rupees 10,000 from her, which he used to pay for the hotel rent. That without having any other option, she went back to her husband, former husband. However, he refused to give her. Next, in view of the aforesaid affair, the police registered Jorhat case number 1908/2019. Is it Jorhat police station?
Originally, my lord, FI was lodged at Jorhat police station, and later on, my lord, transferred to Tezpur police station because the place of occurrence is Tezpur.
And initially, and on receipt of the FIR was lost before Jorhat only.
Jorhat, Rishibari outpost Jorhat.
On the basis of the aforesaid FIR. Lost before Lichubari outpost by GDE number 8, 27/7/2019. Jorhat police station case number 1908/2019 under section 366 of IPC was registered. However, the same was later on transferred to Tezpur police station due to an order of. There was an order of Jorhat court.
No, Jorhat court, yes. Yes, my lord.
Is there any material you have brought in?
In the charge sheet, my lord.
Does it base?
Page 25.
Page 25.
My lord, brief facts background of the case. The brief description of the incident is that on 27/7/2019, the informant Gogoi Ahmed lodged and written FIR before the Jorhat police station and informed that the accused of this case called her by mobile phone with false promise.
Leave that, and then therefore by
the order of the Honorable Court of Jorhat, transferred to Tezpur Sodar police station, and case has been registered at Tezpur Sodar police station case number 2467/19 under section 366.
Which Jorhat court? It was transferred to Tezpur in view of an order of of a competent court of Jorhat. And thereafter, as per police station case number 2467/209, under the aforementioned sections have been registered against the accused applicant. Full stop. After the investigation, a charge sheet in the incident case has been filed on
31/5/2023.
Hmm?
31/5/2023.
31/5/2025, and charges have been framed. And charges have also been framed on, charges framed on when?
8/4/2026, madam.
8/4/2026. And the same is pending at the evidence stage. Full stop. The learned counsel appearing for the accused applicant submits that the accused applicant is nowhere linked in the incident case, and there was no brief that has been
Sorry, my lord, charge sheet was submitted 17/10/2023.
Which page, Sarsit?
Charge sheet 25, my lord.
Huh?
25.
Charge sheet is page 14, isn't it? What are you saying, Mr. Counsel? Page 14 or what? Which page is this?
25, my lord.
25, yes, 25. Then date is charge sheet number so and so, date is 31/5.
31/5 was submitted before the CGM, my lord, 17/10.
Where is that? From where you are saying that it was submitted on 7th?
From committal order, my lord, Annexure 3, Annexure 5, my lord, page 30.
So where it has been stated, charge sheet, about charge sheet? You are unnecessarily confusing. The charge sheet was submitted on 31/5/2023, right? Yeah. Before the court of the session judge, Sunitpur Tezpur. Sunitpur Tezpur, and the same is in the evidence base. It is seen that 3 of the witnesses have already been examined. Like that. Out of 8 witnesses. 8 witnesses. 8 witnesses, huh? How many witnesses are there in charge sheet?
8 witnesses.
8 witnesses. 3 examined already. 3 examined. Then write the learned counsel, if the accused applicant submits that the accused applicant is not committed in the rape in the instant case, and in fact, the informant has eloped with him voluntarily and stayed with him for some time. Who's talking for the submits that there was no false promise of marriage to the accused, to the informant in the instant case. He submits that he was not aware of the filing of the FIR, as well as the pendency of the case, the pendency of the case before the sessions court from Authorised. He submits that in view of the aforesaid, in view of his non-appearance before the trial court, MBW was issued, and thereafter he has been arrested. He has been behind the bars for last 80 days. He submits that in the event of his release on bail, he shall be fully cooperating with the trial, and there is no there is no antecedent of any criminal activities of the accused of the crime. And then it needs to be some other activity. On the other hand, submits that the trial is that means that the conduct of the accused applicant is not good, and in spite of receipt of summons, he did not appear before the trial court, and therefore NBW has to be issued against, NBW had to be issued against him. Taking into account the conduct of the accused applicant, this court should not grant him bail at this stage. Trial court record in the next trial court record in the instant case has been produced before this court and same has been produced. This court has also the submissions made by the council is the respective parties. Taking into account of the fact that the accused applicant is already behind the bars for last 50 days and trial and trial has commenced, and also taking into account materials available in the FIR. This court is of the opinion that at this stage the accused applicant should be granted bail. Accordingly, it is directed that the accused applicant should be released or treated on bail on furnishing of a bail bond of rupees 50,000 to the satisfaction of the learned session judge, learned district and session judge, Smithput, Export, subject to the following conditions: that the accused applicant shall make himself cooperate with the trial, appear before the trial court as and when required. Then you said the accused applicant shall not directly or indirectly make any inducement, treat or promise to any person acquainted with the facts of the case so as to dissuade him disclosing suspects to the court. Accused applicant shall submit his Aadhaar card and PAN card before the learned session judge, the district in session judge in view of the appropriate directions, and the extent the application is disposed of.
Wait, please, your lordship. This is a regular bail application. My lord, accused number 124 was arrested on 7/4/2026. So they are in custody for 55 days. And accused number 5, Giren Nath, was arrested on 11/4/2026.
What's the offenses? What was the mandate?
My lord, the offense is what, my lord, they have alleged attempt to murder and grievous hurt. The whole incident arose out of a plot of land. My lord, in 2020 also, my lord, the informant's brother, he is a known person in that area who used to grab the land of the senior citizens and all those persons. In 2020 also, there was an FIR lodged. My lord, we could gather the FIR today in the morning and we find that it was duly received by the police. Now, with the help of his associates, my lord, a plot of land belonging to a retired government servant, they tried to grab it. Initially, they failed in the month of April. Then subsequently, they again attempted to grab the land. The local people were fed up with him. And it appears that in that area, there are 2 quars. He is one of the quar. They are instrumental in all these activities, madam. Madam, we'll continue at 2.
Yes, 2 quars.
2 quars. And incidentally, one of the
third quar.
Incidentally, one of the quars nickname is same as mine, Bubu Quar. Babu or Bubu. My lord. And everyone in that area knows all these quars. So, well, we'll continue at 2.
Some quars are involved in some alleged offense and some quar is trying to save them over.
No. Wow, we are against this quars. Well, he is not the Ahom quar, but he is from the Morigaon, that Kuch quar.
Anyways, quars, Rajkumars.
Prince.
Yeah, we'll take it.
Into the credentials of the petitioner at paragraph 2. We all belong to paragraph 2 at page 4. We are all the office bearers of a local club there. And my lord, from paragraph 3, my lord, it is
clear that they are all local resident of the area doing business and having a hardware store, the petition number one. They have children. Some of them are doing easy in Tezpur University and all the credentials of all the petitioners I have given up to page 7. Now your lordship will kindly look into the annexures at page 34, annexure 1. This is the FIR dated 12/7/2025. Malab, prior to that, Malab, today we have also another FIR of 2020 against the gentleman Sri Utpal Kaur. And this, with informant of this case, Malab, is the owner of the plot of land where he has now grabbed the land. I will come to that, Malab. With due respect, I beg to state that I, Anil Bharali, am a president of Latakata Bokhista. I state that in the year 1998, I purchased a plot of land situated at Latakata, Pilinkata, covered by dark number so-and-so and pata number so-and-so, measuring 2 kata. However, a few days back, under the leadership of one person, namely Utpal Kaur, a group of persons attempted to grab my Miadipata land. Although with the help of local people, I was able to drive them away. I am concerned about the security of my land. Hence, through this FIR, I am bringing the same incident to your notice. I seek your assistance for the protection and security of my land. The person involved can be given appropriate punishment. Now, against this FIR, your lordship will look at the page 45 now. So, let me go serially. Mali, your lordship will first look at page 37. Mala, Deposit Hazarika is one of the petitioner. His medical report of on the incident occurred on 18/4/2026. That is at page 37. Mala. He is accused petitioner number 2. Mala. He has abrasion over right arm and forearm. Name or alleged history of physical assault. Then page 38 is again another injury report of one of the petitioner. That is at page 38. This is also 18/4/2026. Page 39 is the injury report of another person involved in this case, who is now a witness and he belongs to the other party. But his injury report is also at page 39. Then your lordship will look at page 40. This is again another FIR of 6/4/2026 when the alleged incident occurred, my lord.
This is by whom?
This is again by the landowner Anil Bharali, my lord. Most respectfully and humble, your lordship will kindly look at page 40. Against that GD entry was registered. They did not register the case. Your lordship will come to that later on. Most respectfully and humble, I beg to state that I am a resident of Pilinkata so-and-so, that I am the owner of so-and-so, that on 5th April 2026, at around 5 p.m., 52, it should have been 60 culprits, both ladies and gents, under the leadership of Utpal Kaur, came to my aforesaid land and broke the lock of main gate and entered the boundary along with deadly weapons and threatened my tenants. After getting the information, the resident of Latakata, Pilinkata went to the spot. The culprit under the leadership of Utpal Kaur also beaten them. As a result of which Tapos Saikia, Moon Baisyo, Onul Baisyo, and so. That further, I would like to inform you that Utpal Kaur came in an intent to grab my land. Then your lordship will look at the report against this FIR of the Assistant Commissioner of Police Bokhista Division, that is at page 42. Page 42. With reference to the subject cited above, I have the honor to report that as per your direction and based on the complaint petition submitted by Sri Honor, a preliminary inquiry was conducted. During the course of the preliminary inquiry, the alleged victim was promptly sent to Health City Hospital with a medical requisition through ASI, Kamakhya Odhikari, along with other PSF. Thereafter, the complainant was examined and his statement was recorded. In due course of inquiry, it came to light that a dispute has arisen between two parties regarding possession and disposition of a plot of land, which both parties claim to own. The dispute subsequently escalated into physical violence, wherein one Utpal Kaur was allegedly brutally assaulted with lathi, rod, and sapuna. As a result, he sustained grievous injury and was admitted to Health City Hospital, where he is undergoing treatment in the ICU. It is pertinent to mention that in this regard, on the basis of a complaint petition submitted by the younger brother, this present case was registered. During the investigation, they say their evidence has been collected. So far, the FIR of my lord, this case is concerned, my lord. The FIR is at page 45. And your lordship will find the contents of the FIR. This has been filed by the brother of the...
How many FIRs?
Well, multiple affairs from our side. Whenever we file a FIR, police says that it is a civil dispute. You file a land grabbing case and civil suit. We had filed a civil suit. I'll come to that after this. When they did not take action against our FIR, we have also filed a writ petition before this honorable court against police inaction. And when they went to grab the land, this Utpal Kumar, after his release from hospital, he again grabbed that land. Against that, we have taken a status quo order from the court. And this honorable court is also examining the matter that why police personnel was present when this person was grabbing the land. That is another chapter. Now, this 48 FIR is lodged by the brother, alleging that Utpal Kumar has sustained grievous injuries and he is a doctor. Our case is that, so far injuries and all are concerned, this Utpal Kumar, he has been examined in a private hospital in Gauhati, and we have information that his brother is closely connected with that hospital and one of his relatives also. But those are matters of trial. We'll prove it during the trial that he has not sustained any injury. Now your lordship will find that injury report of Utpal Kumar at page 55, because when we moved the bail application before the learned session judge relied on this report to reject our bail application. And this report at that time we did not have before the learned session judge. This was submitted in the writ petition, therefore we could get a copy of this report. If your lordship looks into the injury report, your lordship will find that initially when the preliminary inquiry was done, your lordship will find that local examination at the time of admission, lacerated own over left parietal temporal region, lacerated own above lip size is very more to alleged history of physical. Now, when they give the current status, then they give all sorts of grievous injuries. Now, your lordship will see the person after his release is moving around in that area in his motorbike without a helmet at Annexure 8, page 56. Now we have another picture of him where he is now in this picture. We have the date and all after filing of just for your lordship's perusal, my lord. If he has sustained so many fractures and all, my lord, how is moving around in a bike and all? But these are matters of trial. But your lordship will see, after that, all of them have been arrested. My lord, all the office bearers of that club has been arrested. Now your lordship will find in regard to this plot of land, my lord, we had filed before that, your lordship will look at page 78. Page 78. This is after his release. He has this police personnel will your lordship will see at page 79. We have brought all this to the notice of the honorable court, and the honorable court is in now session of the matter. How can you don't have any documents of the land? At page 80, your lordship will find that he has now, after his release, he has constructed, in spite of a status quo order, this he has put an excavator, put up tin. Then, my lord, when all these things were happening, then we file another FIR at page 19/4/2026 at page 81. Against this also, police did not take any action on the ground, saying that these are all civil disputes and all. Therefore, we moved this honorable court in a writ petition that your lordship will find at page 85. And your lordship will see that we have specially attributed this police collusion to respondent number 5 at page 85, who is the officer in charge of the Bukistop police station. Then your lordship will find the civil court order after his release. When he grabbed this land, the landowner had also filed a civil suit at page 88, Annexure 16 against Utpal Kumar. Against this also, my lord, this honorable civil court on prima facie satisfied of all our materials has granted, asked the parties to maintain status quo that your lordship will find at page 95. Now, when this in the civil suit, my lord, when the court asks us to take a dusty service, my lord, we went to serve the dusty service to him at page 96. He stays in a flat in that nearby locality with all his associates, my lord. He accepts this notice, but in the endorsement of the notice, although it is not reflected there in the court notice, it is reflected that he gives the endorsement that the lordship will find at page 98. The plaintiff, when he goes to make a dusty attempt to murder by Anil Bharali and his goons, my lord. So my respectful submission is that, my lord, your lordship will find that in this case, some persons have also been granted anticipated bail. We have given that those orders from page 18. Today, I respectfully submit before your lordship that all these 5 petitioners, they are more than 50 days in custody. So far, custodial detention is concerned, my lord, for the purpose of investigation of the case is concerned, it is not required. We are all local resident of that area having business, and some are having their own shops and all. And they're all their family, some of them are school-going children, some of have sick persons at their home and all. So I pray that considering the length of detention, my lord, the other things will proceed in the trial. Civil court where the landowner will take it to his logical end, the WPC will be taken to its logical end. But so far this petitioners is concerned, your lordship may kindly considering the length of detention and seeing that this
He
person,
said how much? 55 days.
my lord, so accept petitioner number 5, who is 51 days, the others are 55 days in custody. And all these medical reports and all, my lord, with utmost respect, my lord, we will prove it during the trial. If he had substance so much of fractures and all, in the last picture we have even given the date on which it was clicked. He is roaming in that area, and he, after his release from the hospital, has grabbed the land. And he has no documents in regard to that land, my lord. In the civil court also, we are going to file a violation petition because even after the status quo order of this case, he has constructed made construction there with a JCB and all. The 2020 FIR is also there. Original. But in 2020 also, my lord, the local people have submitted this FIR. We have given the English translation and the endorsement of the police. My lord, people, they work for their entire life, and if these sorts of persons comes and grab a line, my lord, there will always be a scuffle, or I don't justify that he should be beaten up. He should have taken. But the police are hand in glove. My lord, from 2020, the local people have said he is threatening those people. Whenever we filed the FIR, police said that it is a civil dispute. And none of these petitioners have any criminal antecedents. My learned friend appears for the informant, my lord. And in hand in gloves, my lord, even all the witnesses in the case are his associates. They prepared the medical report because when
The case is basically one FIR.
we have been lodging FIR against him from
You have been
2020.
lodging,
Against us is only that one FIR.
FIR
He says that I was injured.
12/7.
And he suffered grievous injury. 6-4.
What about waves 12/7?
It's our FIR.
It's your FIR.
FIR. We have around 3-4 FIRs against him, my lord. 6-4 FIR, your lordship will find at page.
The initial FIR was filed by whom?
Initial FIR by us in the year 2020 by the local people, my lord. That FIR, your lordship will see the police endorsement. The second FIR was again filed by the landlord because this dispute is in regard to that land.
The first FIR was lodged when?
In the year 2020.
Where is that?
My lord, I have given it just now with the police endorsement. We could get it. It was lodged on 25/10/2020. And your lordship will find we have given the translated copy also. Then we filed the second FIR on 12. There are other FIRs also, my lord. All these people are in custody. That's why we don't have.
This was filed by, who?
My lord, these
Local people.
local people. Your lordship will see the translation at page 5. He has been threatening all those Means whenever he sees some senior citizens, he is like, he has established, I am told, like a Usha Court flat over there. He stays with all his associates, my lord. Then second FIR is at 12/7. The third FIR against him is at 6/4/2026. Yeah, what on what else?
Yes, Mr.
Yes, we have received a case diagnostic. As per the injury report, it is from Health City Hospital. The injury was grievous, Lordship. And concerned witnesses were implicated the petitioners, and two persons have deposed their statement under section 180 BNSS. They have stated that Tapas Soikia specifically implicated. The name is
Soikia-
Tapas Soikia.
One of the petitioner, one
Yes,
of the.
not petitioner.
Because he is the
Other persons were there as per the statement witness of.
Tapas Soikia is not before this court.
he is accused number 4. Because, my lord, he has the lodge over there, he has the most businesses in that area. That's why his allegation. And all the witnesses are associates of him. Even they've done the medical at the health city. And your lordship will see from the photograph, my lord, if he has so much of fractures and all, how can he roam around in a bike and look at his demeanor, my lord?
And what happened to this, inaction of the police? Well,
But that case is pending before this honorable court,
the
WPC.
interim order passed.
No, the court has called for a report. Initially, all those medical reports and all have come. They said that why the police personnel were in that regard. In the civil suit, there is an injunction order, status quo. Violating the injunction order, they are constructing that. That is we'll file a violation petition over there. Again, he after release from his hospital, my lord.
Yes, Mr. Goswami.
Yes, Lordship. Otherwise, we're going to the case, materials are there against the petitioners. Our witnesses are fully implicated the petitioners.
But the-
Specifically,
that is a they are the members of a
yes.
society there, a kind of a society. There are elderly people involved in, and all these people have filed an FIR.
Yes.
Saying that he comes there and he tells me. The FIR is there. And in spite of 3 FIRs, 4 FIRs have been filed, police haven't done anything. They have to approach this court. Now, thing is that as far as injury is concerned, there is some dispute. He's saying that there is not much injury, and your report says there is some.
Yes.
What kind of injury is that?
Lacerated wound over left peritotemporal region, size 6 centimeter into 0.3 centimeter into 0.3 centimeter.
Laceration means like what? Laceration is just like
Makisa.
Depth is 6 centimeter into 0.3 centimeter. And other part lacerated wound above lip size.
it's the size.
Yes.
It's a size.
And last part, Lordship, current status anemia with metabolic acidosis in shock. Presently, he is hospitalized in ICU and mechanical ventilator support of the Health City Hospital. That part is written in the report. Also.
He's in hospital now, but he's saying he's roaming around.
Our report says it is a report of 11/4/2026.
11/4/26.
26. So
11.
1.5 months ago.
So almost.
Lodge.
He must have been released from.
Released,
He's
yeah,
released.
discharged. Also, I have the photograph of the injury. He was kept under ventilation and he was admitted in the hospital for 15 days, Your Lordship. He was first he was under ventilation, then he was shifted to the ICU, then he was discharged, Your Lordship. Whatever be the dispute, Your Lordship, that doesn't give a license to assault a person so brutally.
It's a kind of a mob kind of a thing happened.
Public beating.
No, kind of, because so many people came to that. Lot many people were there.
But it was premeditated, Your Lordship, because he was walking to his home and it was premeditated and it was a brutal attack, Your Lordship. He was first ventilated for 3-4 days, then he was put in the ICU. Now
the report of ventilation.
I have the discharge certificate. I have a discharge certificate, Your Lordship.
Show me the discharge.
This is 6 তারিখে ঘুমাইছে 15 days 20 তারিখে নাকি? Yes.
He was admitted on 6, allegedly released on 20. And immediately after his release, he grabbed the land and the landowner has to file this injunction petition. Now the land is in his possession.
Is there any document you have brought on record saying that this is your land?
No, page 88, the order reflects.
Is it here?
88, my lord. Your lordship will find. Paragraph 5, my lord. The contents of the petitioner plaintiff shown of unnecessary detail is that plaintiff petitioner has insured a compensation for declaration of right, title, interest, recovery of possession, permanent and mandatory, and other consequences relief in respect of the suit land, more particularly described in the schedule of the petition. It is stated that the plaintiff petitioner is the absolute and undisputed owner, having acquired a clear indivisible title over the scheduled land, measuring 2 kathas forming part of so and so, so and so, so and so. District Kamrup by virtue of a registered deed of absolute sale dated 27/5/1998 and has been peaceful, continuous and uninterrupted possession of the same since the date of his purchase in the year 1998. It is further stated that the plaintiff's name stands duly mutated in the revenue record and he has been diligently paying the land revenue to the competent authority without any default. So we have given all these documents today. He doesn't have any document, but after his release, since all this, because they are protecting this senior citizen. So it was a public beating and scuffle from both sides. They also came, but they outnumbered by the public people. And his associates left him and ran away. And therefore, this honorable court has granted a status quo because on day one, we cannot ask for the possession of the land. Now he is in an upper hand so far this civil suit is concerned that he has the possession, but he cannot show any document that he owns this land.
Lordship, as per my instruction, the DAG number that is mentioned in this civil suit is not his land, Your Lordship. It is a different DAG number.
If he had gone to take possession of the land, what order of the competent court he has at page 79 to show that he has taken police personnel with him unless he is in collusion with the police, my lord? And my tenant has been thrown out of that house. He was living in that with a family. That's why we have brought these pictures on record. But we'll contest all these things on the merit, my lord. I don't want your lordship to go into it. But looking into the background of this case, my lord, at this stage only my respectful submission is that further custodial detention will not required. And your lordship can fix the conditions that will not try to intimidate any of the witnesses and all those things. The other cases will take it to its logical end. In spite of his forcefully taking his position, we have not taken the law into our hands. We have approached the civil court and we have asked for restoration of the possession because now possession he has taken it after his release from custody, madam. And he is changing the very character and the nature of the land by using excavators.
Discharge summary doesn't say so.
As per my instruction, the DAG number and that.
No, discharge summary doesn't say anything about his is there in the ventilation and all this stuff.
But initially he was put in ventilation and he was put in the ICU level. The way he was assaulted, if he would have not get proper treatment, at that time he would have left the world by now, Your Lord.
Today, by the grace of God, my lord, he is moving around in a bike without a helmet. No injuries or fractures is seen. Even your lordship will sit, he is sitting there and grab the land of this old person, my lord, senior citizen. So at this,
Mr. Goswami, is there anything in the CD that, let us see, from her document, we can't make out whether, I mean, he was in ventilation or what. It seems that he has some lip injury and like some.
In the case note, it was reflected, Lordship. In the case note, last part of the presently he is hospitalized in ICU with mechanical ventilator support at Hill City Hospital. And that is a report of 11/4/26.
and if your lordship looks at page 55, the current status is anemia with metabolic acidosis in shock under non-endurance support.
Was there any head injury?
Injuries with lacerated parties are not in entire head, Lordship. Polytrauma following age of fracture, BL maxillary sinus, fracture bone, nozzle bone, fracture mandible, minimal right side homothorax, right side 12th rib fracture. Head injury not shown here.
And that is also an impression.
Injury on the whole face, your lordship, facial area. Nose
Give
and
me
all.
the CD.
Lordship.
These people are in custody. Otherwise, we would have looked for his past criminal antecedents in the but local police station is not cooperating. So we could only collect this FIS, 5-4 FIS. And we are also facing opposition from the police because we have made the officer in charge by name in the writ petition. In the trial court also, he did not produce the case diary for 2 consecutive days. Only on the 3rd day, when said the court will consider ex parte, only then the case diary was produced. But at that time, we did not have the injury report. All these documents we have annexed was produced in the writ petition. Therefore, we can annex with the bail petition matter. After we filed this writ petition, my lord, even some of the accused have been taken 2 or thrice to even in police custody. And even they planted some weapons and to show that these were used in the assault. There is no forensic report to substantiate all this. To substantiate the allegations made in the FIR or the medical report, they are now trying to make up the case because we have made the officer in charge of the concerned police station by named party. Some invisible hand is operating, my lord. Otherwise, this police personnel have no business in while this person after his release has grabbed the land of this landowner and thrown out the tenants, madam. And I'm told that the value of the property is now more than 2 crores. That's why all eyes are on that property, my lord. Yeah, ignition.
There is no head injury.
No.
He has made some false statements.
And
Gone through this. He's made false statements.
all these things will collapse during that.
You go through this, you see this. You see the statement of the victim.
Your lordship will kindly see page 78.
You see this.
No stitching guy. Going to the report.
There may be some incident happened.
Happened.
That we can't speak on that. Maybe some incident happened. But he's making some false statement for the police. He just read out. Just give it back. There, see, he's basically saying about his head injury.
Head injury. But in the report.
There is no head injury, and he's not talking about other injuries. Some stitches on his head and all these things. These are all false statements. Nothing is on record.
Let's say party in here periportal lesion.
These are only abrasions. He's saying abrasions, or maybe some injuries are there. The photographs he's giving
Yes.
some injuries may be there. There may be some blood and all these things. But there was no this thing. The discharge, this thing, madam, there is nothing on the head injury. Nothing has been mentioned about the head injury.
On the facial part.
He's saying that like his head has been already totally, moor fali dile. There are several stitches. I am still recovering. All these statements, how?
But I don't know, I have no instructions on this.
Your lordship will see at page 78, he is supervising the eviction.
See, I don't think like you need to keep them inside. Keep them inside. I mean, they are all, when people beyond 50 years of age and they're from the locality only. I don't think they do 55 days already they have spent that. Let them go out. They will cooperate, I'll put some conditions.
Yes, yes.
Mr. B.D. Kumar, the learned senior advocate, assisted by Sir J.M. Kumar, the learned counsel. For the accused applicant also heard Mr. D.P. Swami, the learned APP for the state, as well as Ms. F. Singh for the informant, stuff. This is an application. This is an application filed under section 483 of BNSS 203. Paying for bail to the accused applicants. Action will persist of PS case number 11/2026 under section 61 in bracket 2/118 in bracket 2/109 of BNS 2023. Is there a 12/7? Their affair?
Yes, but their FIR is at pilot, page 45, 45 to 54. 48 is the type copy, type and translate.
It is 6/4/2026.
Yes. And the Assamese type copy is at page 49.
Okay, right. The FIR was lost on 6/4/2026. Releasing interview. Lost by one Dr. Arun
Kumar.
Arun Kumar.
Arun Kumar.
Arun Kumar.
Kumar.
Kumar. Alleging interest that on 6/4/2026, about 4:30 p.m., while his brother Utpal Kumar, along with his friends Sri Raja Lahkor, was traveling from Bakrapara or what? What you read?
Yes, Assamese is Bakrapara.
It's a place called Bakrapara. I don't think there is any place called
Ilinkata that Assam Meghalaya.
Bakodi Para. What is it?
Bakrapara.
Sir, what?
Yes,
Bakodi. What is this?
Assamese is.
You totally distorted the name. There's a place called Bakrapara there.
Wait, Malata, let me see in the police.
From
Police story.
traveling from Bakrapara towards his flat at Ilinkata. The accused persons, including the accused applicants hearing, acting in a pre-planned manner, tried acting in a pre-planned manner with clear intention to kill his brother, struck his brother on his head with a sharp object, causing several severe injuries. That the accused persons had injured Raja was attacked and injured his a friend of his brother, Sri Raja Lahkar. On receipt of that on receipt of the information, he was taken to the brother of the accused, the brother of the informant was taken to the health city hospital. And he was found to be unconscious in the hospital when the informant visited him in the hospital. On receipt of the FIR, the police registered the Bosista PS case number 113/2026 under section 61 of the stroke 118 bracket 2 stroke 109 of the BNS 203. Mr. Bidi Kumar, the learned senior counsel, submits that the issue actually relates to a disputed land, relates to a land and relates to a land which belongs to one
Sri Onil Bharali.
Sri Anil Borali, a senior citizen of that locality. So he submits that the aforesaid land was being used by Sri Anil Borali for the purpose of renting out. For the purpose of renting out by building certain houses there. He submits that the victim, being a known landlord, tried to grab the land, and due to that, there were certain complaints that had been filed by the aforesaid Anil Borali before the police station, before the Bosista police station. Submits that one of such FIR was lost way back in 25/10/2020. 24/10/2020. Wherein an allegation has been made that the victim, along with certain other people, tried to illegally grab the land of the aforesaid Anil Borali. However, with timely intervention of the people, the locality, the same could not be done by the victim at that point of time. He further submits that subsequently also on two other occasions, his land was the land of Mr. Sri Anil Borali was tried to be grabbed or illegally disposes Sri Anil Borali from the land by the victim along with certain other people. In that respect also, an FIR dated 2012/7/2025 was lodged before the police station. He submits that though the affairs were filed, however, no effective action was coming from the police authorities. Police authorities for the reasons best known to them. Full stop. He submits that on the day of the incident,
We had also filed a complaint at page 81.
he submits that submits that the people of the locality, which page? Page
81.
Page 81 is filed by Borali.
Bharali, because police did not take action, so we have to file it before the commissioner of police. But now this gentleman, deputy commissioner of police, is entrusted to look into this land grabbing
Okay,
case.
where is the 81?
81, 19/4/2026.
He further submits that due to the inaction of the police authorities of Bosista police station, Bosista police station, the aforesaid Anil Chandra Borali was compelled to file a complaint before the deputy commissioner of police, Gauhati police district, Kamrup Metro.
Then we filed a writ petition at page 85.
A writ petition was filed when?
85, my lord, the order is of 11/5/2026.
And the incident happened on
6/4/2026.
the subsequent to that.
Yes, ma'am. Because continuously we are following.
And thereafter, they had to, and thereafter, the aforesaid Borali, Anil Chandra Borali had to approach approach the Honorable Gauhati High Court by filing a writ petition against the inaction of the police authorities. He submits that on the day of occurrence, that is on 6/4/2026, the victim person along with some other people, victim along with his associates came to grab the land of the accused, land of the aforesaid Anil Chandra Borali, and after coming to know about the same, the local people gathered there, including the accused applicants in that case, and there was a commotion between the two groups, and wherein the accused, wherein the victim may have got injured, and he was thereafter sent to Hill City Hospital. The learned senior counsel submit that though there was some injury on there was some injury on the victim. The injuries so sustained by the victim were not of very serious nature. As could be seen from the medical report that has been, we have submitted medical report.
Yes, yes.
That has been submitted by the accused applicants along with the instant bail application first. He submits that since the accused applicants, he submits that the victim has already been discharged from the hospital, and he has been seen roaming around in the locality. Full stop. The learned senior counsel for the submits that the accused applicants are behind the bars for last 55 days, except accused applicant number
5.
who
Of
is
51
behind the
days.
bars for last 51 days. Therefore, he submits that other custodial detention of the accused applicants in an instant case is not required. He further submits that as far as the land is concerned, the accused that posted Anil Chandra Borali has already filed a capital suit in the court of
Page 88, my lord. Civil Judge Senior Division number 1, Kamrup Metro at Gauhati. Page 88.
Civil Judge Senior Division number 1, Kamrup Metro, Gauhati, wherein by order dated
This is 9/5/2026.
2026,
Sorry, 7/5.
7/5
Status quo order is that.
status order has already been passed. In view of the aforesaid, factual matters, the senior counsel submits that the accused applicants should be granted bail. DP Goswami, the learned hearing has opposed the bail application that is submitting that the victim was in fact brutally assaulted by the group of people, including the accused applicants, and he had to be hospitalized for several days, and thereafter he had been released. He submits that investigation in the instant case is yet to be over, and therefore at this phase, the accused applicants will not be granted bail. Full stop. And as foreseen, the learned counsel appearing for the informant submits that the victim was in fact brutally assaulted, and he had to be admitted in the hospital, and he was put in ventilation for some days. Thereafter, he had to be treated in ICU before his release. He opposed, the learned counsel opposes the bail application poses the pair of the bail of the accused applicants in the instant case. Next one, this court has heard the submissions going by the counsel appearing for the respective parties, has also the gone through the case diary. Case diary that has been submitted for this court. It is seen from the materials brought before this court that there is an existing dispute about a land which is located at Lotakata.
Latakata at Pilinkata, Gauhati.
Pilinkata. Which has been claimed to be owned and possessed by both the victim as well as the aforesaid. It is also seen that several occasions. It's also seen on the records that on several occasions there were fights. Groups of people regarding the opposite property. It is seen from the application that the accused applicants are residents of the locality who in fact got involved in the incident case due to their involvement in the dispute of the land between the victim as well, the victim and the aforesaid Nilchandra Borali. So this court has reduced his diary in the incident case and has also gone through the medical report as including the discharge certificate that has been produced before this court by the counsel appearing for the informant. On perusal of the case diary, it is seen that it is noticed that though there was no mention of any severe head injury suffered by the victim. The statement of the victim has falsely stated that he had suffered severe head injuries with stitches. This court has taken note of this false statement made before the police by the victim, as nothing on record could be found which shows that the victim had suffered head injury and he had to be given stitches. Be that as it may, without commenting much on the aforesaid aspect, this court is of the considered opinion that since the accused applicants have already spent more than 50 days in the custody, and also taking into account the medical report of the victim, is of the considered opinion that accused applicants should be granted bail at this stage. Accordingly, it is directed that the accused applicants be released forfeit from jail on furnishing of bail bond of rupees 50,000 each, with a security of like nature, to the satisfaction of the
Learned Judicial Magistrate, Kamrup Metro at Gauhati.
Kamrup, Gauhati, subject to the following. That accused applicants shall cooperate with the investigation and shall make themselves available as and when called for by the investigating officer. Number 2, the accused applicant shall not try to influence any of the witnesses or any other person who may be connected to the connected to the case. Then you have. I think that will look at.
Yes,
In,
Yeah, deeply obliged, your lordship.
in terms of the aforesaid directions, for instance, real application is disposed of. CD to be.
Yes.
May it please you. This matter. In this matter, have been engaged lately. Just request. What has happened in this matter, basically, the petitioner has come for pre-arrest bail and his bail, pre-arrest bail has been granted, directing him to appear and register. Subsequent thereto, your lordship, a little bit of issues have happened here. Then, your lordship, this was with regard to a particular case, which your lordship will find the FIR at page 1330. I'm not going to.
Get pre-arrest bill earlier.
Yes, yes.
Then what happened?
Pre-arrest bill, I was granted pre-arrest bail.
This is a B application.
Yes, this is pre-arrest bill. I was granted pre-arrest bail.
Interim.
In interim was granted and directed that I may be, my appear and give my statement. And then, your lordship, today it has come, it can be made absolute. But in between, something has happened. For your knowledge, I am just pointing it out, your lordship. What has happened after this bail application was filed? The person concerned who has filed the FIR. Actually, we initially filed one FIR. I'll just give a gist of the matter. Initially, we filed an FIR which was not against the present, your lordship, FIR informant, and that was not registered. Then we made an application to the Commissioner of Police, but SP, Superintendent of Police, but even then it was not. We came before this honorable court by filing an application, and this court directed that we approach the concerned magistrate, wherein a complaint should be filed so that the FIR can be registered. That was done. Thereafter, the FIR was registered. That is with regard to my case. Now, what has happened after my filing of my FIR? This case was filed after 2 days. This case was filed here.
That was not registered.
That was not registered at that point of time. This was filed.
So this.
Some allegation of this is a company. Company has alleged that some company fund has been misappropriated.
By you.
By me. And there no.
You filed a complaint for what?
There was a lot of issues, your lordship. There was a kidnapping. This is actually the petitioner, his wife, son, everybody was taken away, car taken away. He was working under the.
Anyways, where is that? Where is that interim order?
That interim order. You will find, your lordship, at page 73. 73.
Interim order is at
My case.
592025. Or what?
5925 itself. I'm coming to that.
Oh.
There are some.
5920, long time back. Then what happened?
Yes. Then what happened? There was a direction to appear before the court. Then I was threatened again that if you come and appear, we will file another cases and arrest you.
Who has threatened you?
This informant. Now, what has happened?
Informant can threaten you.
That is the reason I am just pointing it out. Then I filed another AB before this honorable court that they have threatened to file other cases. So other cases may have been filed. So kindly protect. This court has directed the public prosecutor to produce whether some other cases have been filed against the petitioner. Then, your lordship, it was found that at that point of time, on that date, no cases have been filed. That also, we have annexed that order also, your lordship will find. That order, your lordship will find at page 75, initial order. The other bail petition that we filed for protection if other cases have been filed against me.
So you tell me how many AB application is there now?
Two.
Why two AB application? One AB application you have been given.
This is with the AB application before your lordship today. That already I have been given protection.
You have been given interim relief. So as per the interim relief, you did not appear.
I could not appear because of that is the reason I am pointing.
You could not appear. So you have come
I
this.
was arrested.
I was arrested. When I went to give my statement, I was arrested. But prior to that, I filed an affidavit saying that there might be some other cases filed against me. I may be arrested. So protect the court in the PP informed the court that there is no other cases pending against him. When this order was passed, that day itself I went to give my statement. When I went to give my statement, already one FIR was filed on that day. When the court order was passed, I went and I was arrested. This is all recorded in the order of this honorable court. I was arrested. Then I moved this honorable court for a regular bail. In the regular bail, everything has been stated and I was given a regular bail also. And since I was arrested, all the statement, everything, your lordship, I think 5 days I was in custody. Custodial interrogation has totally been done.
You have been arrested in the second case.
Second
case.
second
I mean,
case.
you have been arrested and like you have been given bail.
Then that was a regular.
That's a regular bail. I think that's separate.
Yes, set a separate case, but on the same facts.
Correct. But in the particular this case now, we have also, I mean,
There's nothing remains in this case now because already interim has been given, statement has been taken. Lordship, in the other case,
He has appeared a statement recorded. He has a accountant of a company, T company.
so let him go then. Now, what is there?
Allegations
Just
of,
already been granted bail in the other case with the same indication.
yes,
Regular bail.
yes.
in this case also, he has appeared statement also recorded in this.
And why this additional affidavit?
This affidavit to bring on record these particular facts, subsequent facts. During the pendency, he's arrested, again, he was granted bail. All these were brought so that, your lordship, there is no laxity on our part.
Okay. Heard. YS Mannan, the learned counsel, preparing for the. Also heard Mr. V.P. Goswami, the learned KPP for the state. This is an application of the section 483 of section 482 of BNSS. BNSS paying for. With Dulakat, this case number 162. Under section 61 in bracket 2, stroke 318, bracket 2, stroke 316, bracket 4, 336, bracket 3 of BNS 203. The gist of the fact involved in the instant case is that an FIR was lodged on 27/8/2005, which reveals that petitioner number 1 being an employee of a company, namely a wrongdoing company, had allegedly misappropriated money from paused documents and committed breach of trust. And he had unauthorizedly transferred company funds to his personal account without any approval of the management of the fund. It was also alleged that in the affair that the family members of the petitioner number 1 were also involved in the aforesaid misappropriation. The instant secretary application has been filed by all our family members.
Yes.
By the
His wife,
by the accused number 1 along with his
family member.
along with his other family members. Wide and order to take 59025, a covenant grants has already granted interim pre-arrest bail to the accused applicants to the direction to the accused applicants to cooperate with the investigation as well as to appear before the investigating officer within a period of 7 days from the aforesaid order dated 5/9/2025. Mr. Y.S. Pannan, the member appearing for the accused applicants, meets that in terms of the aforesaid interim order, the accused applicants have already appeared before the investigating officer and got their statements recorded. He submits that since the accused applicants are cooperating with the investigation and they are going to do so in future, the accused there is the custodial retention of the accused required in the instant case Jeff praised for making the interim order dated 5/9/2025 absolute. Mr. DP Goswami, the learned APP, has also confirmed that accused applicants have appeared before the investigating officer and have been cooperating with the investigation, taking into account their aforesaid submissions as submissions and that the accused applicants are cooperating with the investigation. This court is of the considered view that the interim PRS bail for granted on 5/9/2025 should be made absolute. Accordingly, the instant AB application is disposed of by making the interim order dated 15/9/2025 absolute. Absolute. That will do.
Yes. Yes. Obliged.
Here, Lordship, what has happened, Lordship, the concerned TCR was called for in respect of Sri Bhumi PS case 501 of 25. Now, Lordship, the trial court record that has been received, that is with respect to 510.
So the different cases.
Yes, Lordship, wrong TCR has been received.
And we'll put us their different date.
Lordship.
Heard Mr. A. Ahmed, the learned counsel, appearing for the accused applicant. Also heard Mr. B. Sharma, the learned AP speak. Mr. B. Sharma, the learned APP submits that the PCR in the incident case has been had been called for by this court. PCR has been received. PCR has been received, but the same relates to a different case.
Yes.
Full stop. Therefore, he submits that the case should be posted in a different date and a reminder should be given. And send which court? Reminders should be given to the district and to the civil.
This is presently pending in the court of Chief Judicial Magistrate Sri Bhumi.
Chief Judicial Magistrate.
Sri Bhumi.
Reminders should be sent to the Chief Judicial Magistrate Sri Bhumi. Right. Registered to send a reminder, taking into account the submissions made by the learned APP, registered to send a reminder for procurement of which is the case number?
Sri Bhumi PS case number 501 of 25.
Now it is Lordship PSC case number 223 of 2026. Now it is has been registered as PRC case number 223 of
Okay, but just a minute.
2026.
PS case number 512025, which has now been registered as
PRC case number
PSC case number
223
of
2026.
2026. From the court of the Chief Judicial Magistrate
Sri Bhumi.
Sri Bhumi. Let the matter be listed when
It will come by the registry, Lordship.
Interim order is there.
2 weeks.
Interim order is there. That might be.
Weeks interim order so passed earlier shall continue to the next.
Pablo.
The CD has not been received and they are on interim, Lordship.
Your name?
J. Das, Lordship.
MS J. Das, the London Council. CD in cases yet to be received. Interim order so passed earlier shall continue to the next date of listing. Let the matter be listed.
14, Lordship. 14/6.
14/6. Let the matter be listed on 14/6. 15/6.
Obliged.
15/6.
Yes. Because petitioners are in interim, they have appeared on statement also recorded. Allegation is paying from taking some money to give the admission, Lordship, in a class 10. As per their statement, their appearance statement that it was done by another person, Binoy Mishra. The person he has expired already. But they are this one is the principal of that.
Let him. Heard Mr. G. Learned Counsel appearing for the accused applicant, also heard Mr. Mr. BP, Mr. DP Vishwami, Lana Deputy for the state. This is an application of the section 4 of BNSS. Paying for clear is being use application in connection with dispute case number 986/2025. The section 406/420/465, 466/468 IPC. This court by an order to take by an order dated 25/3/2026 has granted that one interim 3 years bail to the accused applicant. Accused applicant with a direction to the accused applicant to appear before the investigating officer within 7 days and to cooperate with the investigation. The learned counsel appearing for the accused applicant submits the two terms of the proceed further. With a 25/3/2026, the accused applicant has already appeared before the investigating officer and what is statements required. Further submits that the accused applicant is fully cooperative with the investigation and therefore his bail application, his interim bail application, his interim order should be made absent. So, Mr. DP Vishwami, he has also confirmed that the accused applicant is before the investigating officer and cooperating with the investigation in view of their prosecutions and being found that the accused applicant is cooperating with the investigation, cooperating with the investigation. The interim order should pass on 25/3/2026. It is made absolute. In terms of the direction, the instant reapplication is.
In this case, only charge sheet submitted.
And I am in interim, my lord, on 12/3/2026, my lord.
You go and appear then. When you are going to appear?
My lord, date is fixed on 15/7/2026.
In 7.
2026.
10 days time,
Huh?
10 days time, 100 more things.
10 days, my lord, 30 days at least.
Why 30 days?
I, a very old man, my lord.
Huh? How old is he?
He's 60 years old.
60 years. 60 years is a very old man.
Yes, we are lordship, man.
The 60 years is a very old man.
Not
He's
very
just
old
man.
man.
How old are you?
60 years.
How old are you?
I am, my lord, 42.
Huh?
I am 42.
You'll be also 60 after some after a couple of years. 60 years is not a very old man these days. 60 years, people go for so many things. Go and appear within 10 days. Not Mr. HR Sodhu, the other council applicant for his applicant. Also for
White CS number 24/26, dated 24/3/26.
The case is already numbered.
Yes,
Case
yes.
number 220/20.
This is an application for something. Application under 450 for 1 year is paid. That is the applicant in connection with Tata Tangi PSP registered under section 406, 420, 471, 468, Indian Penal Code. Allegations in the FIR. When was the FIR filed?
FIR filed, my lord, 16/1/2026.
And the allegations in the 61,
2026.
2026 is basically for alleging that leasing is as misappropriated certain funds of certain funds of sale for domain masjid. The learning APP preparing for the streets as the submits the charge sheet in the instant case is already filed by charge sheet number. So in so the
24/26, dated 24/3/26.
view of the aforesaid, in view of the aforesaid, the instant application, instant intercepted application of is disposed of with a direction to the accused applicant to appear before which court?
Before JM first class 2, my lord,
JM first class, JFMC two
to at Sribhumi.
at Sribhumi within a period of 10 days within a period of 10 days from passing of this order and seek passing of this order and seek appropriate relief if so advised.
But then,
The 10 days and the interim order so passed earlier shall continue till his appearance. Till his appearance. Till his appearance within 10 days before JFMC. Sribhumi. JFMC 2 Sribhumi.
JM first class 2, my lord.
JM first class 2 Sribhumi. In terms of the appearance direction, the instant will be application. So within 10 days you appear. Within 10 days, if till 10 days, you'll be in interim.
One appearance, my lord, interim may be continue. What one appearance, my lord, bail may be that bail may be continue.
I have already dictated you appropriate relief you ask.
My lord.
27 also same pair, lordship, charge sheet submitted.
Petitioner number 1 is already interimus there. In respect of petitioner number 1, interim is there.
Others interim is not there.
Who is not?
How many are there?
Lordship.
One is to
Two persons are there. Let them appear, Mr. Goswami, there. Both of them, let them appear within 10 days. 10 days, you don't do anything. Where is the order, earlier order?
Here at 11/3/26.
Heard MSF Begum, the learned counsel appearing for the accused applicants, also heard Mr. B.P. Goswami, the appealing for the state. This is an application of section 482 of TNSS will be the three. Praying for grant of 3 years bail, the accused applicants. Accused applicants in connection with Galsworth Police Station case number 10/6, registered under sections 49 stroke 326 in brackets all stroke 3/5 of BNS 2023. This court, a courtly bench of this court by order of its 11 which will be the process. Granted interim period PRS 26 interim relief in connection with the accused applicant number 1. The learned APP submits that the charge sheet in the instant case has already been filed, right? That's the number.
25/26 dated 31/3/26.
Before which court? Before?
Nalbari district. CGM Nalbari. The Nalbari district.
CGM Nalbari. Mr. Goswami, you have any?
No, we have not received that information, where only charge sheet number was given.
You always take the code also because sometimes it becomes difficult.
Yes.
Always ask for that.
Not.
Charge sheet and which code?
Sometimes we have received a message that we have reflected.
Yeah, you please clear because I experienced this thing on earlier cases also. The code is not there, it becomes difficult.
That's it.
You are saying CGM Nalbari?
Because this PS is under Nalbari district, Your Lordship.
Nalbari district, but
CGM Nalbari. I cannot say, my lord, which code will allot it.
Can you find out?
You can mention it as jurisdictional code.
Okay. Okay. So I filed before the jurisdictional court. In view of the aforesaid, this instant review application is disposed of with a direction to the accused applicants to appear before the concerned court within a period of 10 days from passing of this order. The interim orders will pass. In right. It is direct that in their appearance before the before the consent for the interim will be granted by order 11/2006 shall be extended to accused applicant number 2. Accused number 2 also, they are applying with them appear. In terms of the opposite direction, the instant review. So you go and appear. Let's.
As per earlier order, Lordship, petitioner appeared before IO, recorded his statement. Lordship.
Here 28 and 34 are from the same FI, Lordship, can be taken up together, Lordship.
I am already 3 times appeared before IO, Lordship.
Okay, Mr. Sharma, like we are making it absolute, there's nothing.
Lordship, just a few submission, Lordship, I have to make. Lordship, the case relates to taking up of money from different persons, Lordship, in the name of giving loans. Now, Lordship, they have collected a very huge amount, Lordship, from all these persons. Their 180 statement has been recorded. Now, what has happened, Lordship, after they were granted interim, they are now threatening those victims, Lordship.
Threatening those victims?
Yes, and that has been reflected in the case diary, Lordship, wherein the IO has said, Lordship, that because of that, Lordship, 2 non-FIR case has been registered against them because they are threatening the victims, Lordship. That is the only thing I'm.
Lordship, I am 3 times appeared.
And not.
But you are threatening the victims?
No, I am a government employee also.
Absolutely not.
No, I mean, how then I have not seen a case wherein the police has wrongly stated that like we have,
My name is, I am not a FIR person also.
We have not FIR named, Lordship. We have not FIR name. Subsequently, name has been added, Lordship. And 3-4 times we've been called in the police station.
All are appeared before.
All appeared, duly cooperated. Another one is the wife of petitioner too. She's a Banganwadi worker, Lordship.
My petitioner is a ward boy of a medical.
This threatening part, Lordship, this is one aspect of the matter. Another aspect is, Lordship, they have collected around 80 lakhs from different victims. And in respect of that, Lordship, they have executed one money borrowing agreement with all those persons. That has also been submitted by the informants. Now, Lordship, money has not been recovered. Now, in spite of that, Lordship, now they are threatening the informants, Lordship.
I mean, we'll cancel your bill.
Yes, Lordship. Because the specific note of the specific note in the IO, the bail objection, as well as in the case diary, Lordship.
My part of the threatening is
not against the wife, Lordship. The petitioner number 2, Minu Hazarika, against her that allegation is not there. But regarding, Lordship, this Suresh Das, alias Keshav Das, and Manoj Bharali, that allegation has come out. And regarding that, Lordship, 2 non-FIR case has already been registered. The numbers are also there, Lordship.
Absolutely,
These
they
victims
have
are, Lordship.
taken the just to project a case. This has been.
I am government employee. I am for 3 times appeared before I also.
Already cooperating, never miss it, guys, Lordship.
Here, Lordship, allegation against the one Panjal Borua, Lordship, not against us, Lordship.
Panjal Hazarika.
Panjal Hazarika. He was arrested and getting bail also.
এপিআর করার জন্য দিবেন না, এপিআর করেছে, এপিআর করেছে, কিন্তু মই কোৱা নাই, থ্ৰেটেনিং কৰা পাছটোহে কৰিছো।
We'll give a condition, Mr. Sharma,
Lordship,
that in case, father, this thing, will have a right to
Lordship.
come to.
Lordship. Lordship.
Only that part, Lordship may record, Lordship, that due to this subsequent threatening, 2 non-FIR cases has been registered. That Lordship will kindly, those are Lordship, 2 non-FIR cases has been registered. One is Lordship, Lordship 20/26 and 21/26.
2 non-FIR.
Non-FIR case, Lordship. Gopur, non-FIR case number 20/26 and 21/26.
20/26.
26 and 21/26.
All this Gauhati, no?
Yes, Gopur.
It is registered, Lordship, before this case, Lordship. Our case is 26, 26/26.
26/26. But this is prior to Mr.
Non-FIR, Lordship, the numbering will be different probably, Lordship.
But these 2024 number, no,
Numbering will be different.
numbering may be different.
Different, Lordship.
Numbering may- But there are some allegations against me.
Because it is specific stated after they were granted interim, they are threatening, Lordship.
If you do that, then your bail will be considered. Okay, right. Heard Mr. L. Gogoi, the learned concept appearing to the accused applicant. Also heard Mr. B. Sharma, the learned APB, the state incident application. In the section 450, to copy and assistant to paying for grant of 2 years bail to the accused applicant. In connection with Gauhati PSC's number 26/2026, based on this 316. Okay. Stroke 318/4, stroke 319 of units to be complete. The allegation in the fact is that the accused applicant is involved in promising jobs against taking money. Taking money against promise of jobs. Anyway, by the order dated 16/3/2026, the criminal bench of this court was already granted. Interim period is being to accused applicant with the condition that the accused applicant shall be for an investigating officer within 7 days from the date of passing of the order and cooperate with the investigation first. Mr. The Lord Counsel appearing for the accused applicant submits that in terms of the order with 16/3/2026, he has appeared before the investigating officer and got his statements recorded. However, Mr. B. Sharma, the Lord APP has submitted that after getting the interim relief from this court, the interim court, the accused applicant has been involved in taking the witnesses in the instant case. And due to the aforesaid, 2 non-FIR cases being 20/26 and 21/26 has been lodged before the Gauhati police station.
Yes.
Before the Gauhati police station. Gauhati police station against whom?
Against Lordship, the
one applicant.
the wife, Lordship, these 2 petitioners.
My only one.
Okay, in your prison, husband and wife is there.
Yes. One is Lordship
Then-
Suresh alias Keshav Das. That is AB 559.
Then you can write against, in this case, you can write against the, we'll pass different orders.
Yes.
So against the accused applicant, against the accused applicant. Therefore, he submits that, therefore he opposes in making, opposes the grant of PROCEEDINGS. This court has held patients made by counsel respective parties and consideration of the fact that there is a contest already here before the investigating officer and officer is recorded. His name was not there in the FIR. Is of the view that the interim order should pass the absolutely. However, the same however, make absolute wisdom. However, the investigating officer shall be at liberty to approach his court for consideration of bail in the event of any treating or any kind of activities which is not in terms of law. In terms of law, committed by, if committed by the accused applicants. In terms of the opposite direction, instant bail application is, AV application is disposed of.
Problem.
And here also we write in the same order. We see, only thing is that this non-FIR cases, non-FIR cases against these two non-FIR cases are against these two people.
Yes, these two.
Then,
Against wife.
Not the wife.
against the accused applicant number 2. Accused applicant number 2 in this case. No, accused applicant number 1. Manoj Bharali.
Yes, yes.
Manoj Bharali.
Against that.
Baki same. Only that non-FIR case. Against not both the accused applicants, against accused applicant number 1. So if they do something like that, you come, we can see.
Oblige that. Deep depth.
30 Lordship, charge sheet has been submitted and petitioner is on interim.
Lordship, this is a covert case, Lordship. Similarly situated persons are granted absolute bail, Lordship. Charge sheet file, similarly situated person arising out of same FIR. No, order, petition from you.
Already the case is fixed.
Petition, give it to me, petition.
Case is already
Lordship,
fixed for appearance, Lordship.
Case is fixed for appearance, charge sheeted, and Lordship, as the sessions tribal case, so Lordship, record was called for, and similar order has been passed regarding another accused arising out of same FIR, Lordship. So Lordship may kindly allow us to appear, as we are also similarly standing as these accused persons. Here, Lordship, are 2 accused petitioners, Sabina Yasmin and Frida Khatun.
Okay, we'll pass that order.
Similar order.
You write, heard Mr. G. Somewhat, and then at council, okay. Please remember that I did it. Then you write, this is an application, the section 452 of PRS. In front of the accused applicant connected with availability case number 28/4. Registered under sections 140 so physical name bracket 6 351 bracket 2 of DNS 203. The learning to pick is communicated in the instant case that instant case charge sheet has been already filed. Charge sheet number is there? Yes. Charge sheet has already been filed.
Charge sheet number is Lordship 72/26, dated 22/4/26.
Which code?
Oh, Lordship.
DCM not Salmora.
Yes, Lordship.
Huh?
Yes.
DCM in bracket M. Not
SBM M, North Salmora, available.
That's something like that. Consider the opposite aspects. Opposite. No. Because it has already been filed. I can considering the opposite aspects and since the accused applicant has been cooperating with the investigation, this court is order protections. Opinion that the accused applicant should be allowed to appear before the SDG and not someone within a period of 10 days from passing of this order. The interim order so passed earlier, said continue till his appearance for the SDGM and not someone for appropriate period if so advised. In terms of that, the instant bill application, the application is disposed of.
Deeply obliged, deeply obliged.
How many cases are there?
Lordship, we were required.
Wait, please, Your Lordship. Wait, please, Your Lord.
Yes.
In this case, my lord, so AB, my lord, I was protected, my lord.
Mm.
And my lord, during pendency of this case, my lord, the charge sheet has been laid, my lord.
Go and appear.
Well, that's the problem, my lord. This issue was raised on the last occasion, my lord.
Mm.
The case is, my lord, under section 109, my lord.
Mm.
It's a sessions tribal case.
Mm.
So now someone has not, I have not received someone.
Mm.
So I have to appear before the magistrate court, my lord.
You'll have to appear for the
My
meeting.
lord, that's why, my lord, the question arose, my lord. Today I am not arguing, let this point be, my lord, whether, my lord, the interim bail granted to me, my lord, whether it will be continued till end of the trial or.
No, it will be there only till you seek for an appropriate relief.
Yes, ma'am.
So you go and appear, filing a appropriate this thing, till that will be.
Well, that's the issue, my lord. So I want to argue only on this point, my lord. If your lordship fixes the matter on Thursday, my lord, I have some.
What do you want to argue?
My lord, whether I have to go there and my my interim bail will continue till my appearance, or it will.
This is the order we are passing, we'll pass
Yes,
the order.
that is the order your lordship passed, my lord. Passes, my lord, generally, my lord. But I have some authorities, my lord, in this regard, my lord. So I am to argue on this point, my lord. Can it be on Thursday, my lord? Because, my lord, this matter was referred to a larger bench of 5 bench, my lord, Sushila Sagorola case, my lord. Where it was argued, my lord, whether, my lord, the question was whether this bail will continue till end of the trial or till the appearance, till I appear before the trial.
But that always, that is always a discretion of the court.
No, my lord.
Is there any law?
Yes.
Like that, once interim bail is given, then it will. Go.
Yes, my lord. That was the two issues, my lord. That was the two issues, my lord. Whether the protection granted to a person under section 438, my lord, should be limited to a fixed period as to enable the person to surrender before the trial court, or he has to prefer a fresh appeal, my lord, a fresh bail application.
We see, the order, this court usually passes,
My
the
lord.
interim order will be continue
Continue.
till a particular time.
Yes, my lord.
And on that date, if you are advised, if you think that you should seek for an appropriate bail, then you have to seek for an appropriate.
Yes,
bail.
my lord. Exactly.
So
If
there is no question of surrendering.
no, my lord, surrendering, no, my lord. So it is a, my lord, sessions tribal case,
You
my
have
lord.
already appeared before the investigating officer.
Yes, my lord. I have appeared, my lord.
Statements recorded.
Yes, my lord.
Interim bail already been granted to you.
Yes, my lord.
So that shows your conduct is good.
My
And showing your conduct,
my lord.
you appear before the court,
My lord.
and the court will, usually in the high court, what happens? High court, if you are cooperating with the investigation, you
But-
appear before the court.
That is the core point, my lord.
Huh.
If I appear before the magistrate court, my lord, it's a sessions tribal case, my lord. But the magistrate may send me behind the bars also, my lord. He may reject the bail, my lord.
No, that usually doesn't happen. I mean, high court doesn't. do
No,
it.
my lord.
Why
That
magistrate will do it?
no, that we cannot presume, my lord. At now, my lord.
Magistrate cannot do. Magistrate.
That's why, my lord, I'm relying upon authority, my lord. Whether it is specifically regarding, my lord, the court held that the protection granted to a person under section.
Okay, we can fix it for argument.
Yes,
but
my lord, on Thursday.
One thing is there, Mr. C. Bail before charge sheet, bail after charge sheet are two different things.
Yes.
Considerations are different.
Yes.
Correct. So a bail has been granted to you before charge sheet,
My lord.
and without looking into the charge sheet. Correct. The pre-RSL bail has been given. Now, if you want to argue that pre-RS bail which has been given to you without consideration of charge sheet, that will go till the end of the trial. I don't know. That has to be some.
But I think, my lord, there is two options before your lordship, my lord. Either your lordship will go through the case record, my lord, as because charge sheet has been late, my lord.
No, you place that I mean that we can call for. I mean,
Yes.
charge sheet we can call for. That's a different option.
my lord,
But without looking into charge sheet,
my lord.
only on the basis of the interim order which has been passed to you, if you want to argue that should continue till the
Yes,
end of the
exactly,
trial,
exactly.
cannot be accepted. This
Well,
thing.
that's what have been held by the 5 men.
Correct. We'll have to look into.
Yes,
it.
that's
I
why,
mean,
my lord.
because see, I have not gone through anything.
Yes, my lord.
Neither the case law you are referring to,
Right.
nor any ratio on that point.
My lord.
But what I'm saying is that like these are two different considerations while granting bail.
Right.
One is like looking into the charge sheet is a different ground altogether, and without looking into the charge sheet is a different ground altogether because such materials were there before the court.
That's why that's why I am argument. Can it be on Thursday or Friday?
Then so the materials have to be visual lordship. Because either way lordship will have to go to the records. The
Let
records
us
will be
see
necessary.
what is his, if it is a typically a legal point,
Yes.
that typically a legal point, if the court has discussed about those things, the charge sheet and all these things that they have discussed, then we may not require it. But like if those things are not discussed in that case,
It has been discussed, Lordship. It is based on case to case, based on the materials that are available on the records. Lordship will have to verify that. It's not a universal thing, Lordship, that bail will be continued till trial.
No,
It
well,
depends on case to case,
no,
based on the materials, yes.
Well, that's the core issue which has been referred to a larger bench, my lord, of 5 judge, my lord.
Exactly.
And the reference was to that point, my lord, whether the life of an anticipatory bail should end at the stage of filing the charge sheet or whether at the time of giving summons to me.
but it doesn't end. Because
That does.
it doesn't end because you always have an option to go to the court to get it extended.
That's why, my lord, I want to argue only this point, my lord. Let the law be there, my lord.
Okay, let us.
Because generally, my lord, with all respect, my lord, some courts also, my lord, in such a situation, my lord, the interim bail which was passed by this court, my lord, is made absolute, my lord. I have the case laws also, the similar coordinate benches, my lord. Now, because it is my lord, sessions tribunal case, my lord. So if I appear before the magistrate, my lord, he
So
must say-
interim bail is made absolute.
my argument will be, it should be made
Now, tell me one thing, what happens
ma'am.
when a case is being investigated and charge sheet is not filed and interim bail is, the bail is granted, interim bail is made absolute.
my lord.
Then once the charge sheet is filed and trial starts, then what happens? Are you supposed to take a new fresh bail application, file a bail or not?
That's a regular bail, my lord.
And that's what the interim bail, whatever has been given,
My lord.
that has been curtailed because of your this thing, because of filing of the charge sheet. The same logic goes.
That's the point I have to argue, my lord. That's the point I have to argue, my lord.
I cannot make it absolute because once charge sheet is filed,
My lord.
that thing has become a different.
But the court
of
has
the-
answered, my lord. That's why, my lord, Sushila Agarwala's case, my lord, of 5 benches.
Because see, in other cases also, see, in your case, charge sheet has been filed.
My lord.
There are so many cases where charge sheet hasn't been filed.
My lord.
We have already granted an interim, and we have seen that the conduct of the person is good and he's cooperating with the investigation. We make the bail, anticipatory bail absolute, correct? Now, after 2 months or 3 months, whatever, the charge sheet is filed. Once charge sheet is filed, you can't say that like my anticipatory bail has been granted and it has been made absolute. So I'll be on bail also. That you cannot do. You have to seek a bail, regular bail for the court.
And that's the point, my lord, whether, my lord, charge sheet, the last occasion, there was a point, my lord, there is a query, my lord, whether the charge sheet which has been filed against me, my lord, whether it is, my lord, sessions tribal case or not. Because generally the PP, I was also on the other side, my lord, we got the instruction, my lord, charge sheet has been laid. Under what section, my lord, and against whom, my lord? Because here in the instant case, there are 5 numbers of accused. Whether charge sheet has been laid against me, and if charge sheet is laid against me, under what section, man? Whether it's a sessions tribal case.
You get information, Mr. Sir.
That is very, very, but he will also be not able, well, we can talk with the IO, my lord, at best, my lord.
Can fix it on Thursday, there is no problem.
So records will be necessary, Lordship, either way, because at the end of the day, it will depend on the records.
No, the record facts will differ, my lord. First, this point, my lord. If your lordship satisfies.
No, that's
okay.
what, but you are saying that like, I said, you are not sure against whom those choices are.
That is also not clear.
Then we'll have to call.
That he can take a telephonic instruction from the IO.
Otherwise, he is the accused number 1, Lordship. Accused number 1 in the FIR.
I guess the question.
He's the accused number one in
Yeah,
the
I'm
FIR.
accused number one. Whether it is, charge sheet has been laid against me, my lord, under what section? ma'am? Because summons are not yet issued, my lord.
That information you can also get it. Mr. Doctor.
Anyway, Rosh may fix it on Thursday, my lord. I'll have a.
Okay, on the prayer of the learned council, appearing, later matter will be listed on Thursday will be.
Thursday will be, my lord, third, fourth, my lord.
Mr. Sharma, you also bring something,
No, sir.
if there are some materials,
I'm obliged. But the interim will continue.
interim order supposed to have this.
I'm obliged.
Lordship, we have received a case that a petitioner is an interim.
Hmm?
Petitioner is an interim, Lordship, the appearance statement recorded and the injury report shows simple and blunt injury.
Case are received,
Received. He has appearance statement recorded, Lordship.
okay. Then we'll make it absolute.
Lordship.
Heard Mr. J. Pine, the learned council, according to the case applicant, also heard Mr. P. Swami, the learned looking for the state. This is an application on the section 482 of BNSS 2023, praying for pre-arrest bail to the accused applicant. Who is applicant in connection with.
My lord, in this case, my lord, there was no
No FIR.
registered, no FIR was registered at the time of filing this. petition.
Now it started or not?
Now it is Mokalmua PS 20/26.
In connection with Bukalpua, PS number
20/2026. No.
20 of stock 2026.
And I was protected only, there was no, my lord, order of faith.
Yeah.
As such.
Considering no course.
No course of action was
No
taken
course
that
taken.
all put up because FIR is not resolved.
Okay. Then we abide an order dated 22/2026. The coordinate bench of this court has passed. Coordinate bench of this court in interim is passed an order directing no proceedings against the accused applicant by the Adabari police station. There is one Adabari there also, Mukalmo also.
Yes, Adabari outpost.
Adabari outpost under Mukalmo police station. It is seen that when the interim order was passed, the aforesaid case was not registered. And the aforesaid case was not registered by the police. The learned APP, the learned APP submits that in terms of the aforesaid order dated 23/2026, the accused applicant has appeared before the IO and got his statement recorded and got his statement recorded and fully cooperating with the investigation. Mr. J. Pine means that since he is already cooperating with the investigation, he should be allowed to go on a pre-arrest bail. Full stop. Taking into account the possibilities made by the counsel appearing for the respective parties, this court is to consider that the accused applicant should be allowed to go on pre-arrest bail on furnishing of a bail bond of rupees 20,000 with a severity of like nature to the satisfaction of the arresting, to the satisfaction of the investigating officer in connection with, what was the case number?
20, madam. Mokalmua PS case number
Case number
20/2026.
20/2026, subject to the condition that the accused applicant shall cooperate with this. In terms of the aforesaid direction, the instant application is.
Always.
May I please your lordship? I am on interim, my lord, and my statement recorded, no condition has been violated. Here, lordship, what happened? The case is
In
that
APR, lordship, the allegation is of forgery documents, lordship. Custody interrogation by the VP, lordship.
But he is appearing. heard Mr. G. Somo, the learned counsel, according to the accused applicant, also heard Mr. B. Sharma, the learned applicant for the state. What is the allegation?
Allegation is that the informants sublet a bill to me and taken me 3 lakhs of rupees from me. Thereafter, Lordship, he filed this FI stating that all these agreements are forged by me. But Lordship,
The allegation of when you write the allegation, allegation in the same case is about forgery of signature of the informant by the accused applicant. When you write by order dated 23/2, which is the interim order? By order dated 23/2/06, the coordinate bench of this court was already granted. The interim period is been the accused applicant. Accused applicant. Then it comes for the accused applicants, it means that terms of the order dated 23/2/06, the accused applicant has already appeared with the investigating officer and got his statements recorded. In view of the officer, he submits that this interim date be made absolute. Interim period is then made absolute. Mr. B. Sharma, the APP has confirmed that the accused applicant has appeared before the IO and cooperating with the investigation. In view of the officer, the interim period is after the is made absolute. Made absolute and made absolute in terms of that.
highly obliged, man.
35 Lordship, a report was called for if any FIR has been lodged against the present petitioner. And we have received the report, no FIR has been lodged against him in Borpeta, Lordship.
Actually, my lordship, it is from the Kolgazia police station, my lordship.
Sure.
We have received the report from Borpeta, Lordship.
So Borpeta Sadar was written here.
Yes.
So no FIR is lodged.
They have not
So
stated.
press report was called for Kalkasia also. You have not received it.
Probably, Lordship, then we have to, again, I will have to inform the Kolgazia.
18.5 order, if you see, Kalkasia, later press report with all from Kalkasia.
Kolgazia. Lordship, I'll take the instruction.
APT submits that report from Kalkasia police station is yet to be received. Let the matter be listed on.
Next week?
Hmm?
8, 9, Lordship.
9, my lordship, I have some
9
difficulties. My lordship, 9th, I have some difficulties. May it be earlier or
9 June.
9 June, I have lordship. I have
You're going out
legal case.
station, where?
Lordship, I have a case fixed in the Haplong, my lordship. Criminal appeal, my lordship.
Then,
8 may 7 or 10, 11, 12.
7 is there.
10th of June?
10, my lordship.
10th of June.
10th of June.
Developments.
Lordship, they are on interim. Petitioner's interim CD has not been received.
Lordship, under instructions, under instruction, may be pleased to withdraw this case, your lordship.
Withdraw this case.
Withdraw this case.
I heard Mr. Your name?
A.N. Iqbal.
A.N. Iqbal, the learning counsel appearing for the accused applicant. Also heard Mr. B. Sharma, the APP for the state. Mr. Iqbal submits that he has instructions to withdraw the instant AB application. His prayer is allowed. Instant AB application is dismissed as withdrawn.
Already earlier, interim order has to be vacated.
Interim order so passed earlier. To be vacated. Is to be vacated.
Oblige, your lordship.
Is hereby vacated.
Party lordship, we have received the case diary, but up to that case diary not received. FSL report required in this case. The PM report, the opinion is kept pending, lordship, because non-receipt of FSL report.
That's the offense.
Allegations were 103.
Then we'll wait for the
FSL report.
heard Mr.
K. Islam.
K Islam.
Islam, the learned counsel appearing for the accused applicant, also have Mr. DP Goswami, the learned APP for the state. The learned APP submits that after the very instant case is yet to be received. Let the matter be listed on
12-6.
Hmm?
12-6.
12/6.
Well, look, one thing, the last order, the accused number 1 and 3. The Honorable Court was wanted to clarify Rosidul Islam and alias Shahidul Islam. And accused number 3 is Shahidul Islam.
So,
Are the same or different person that was wanted?
so then you file an additional affidavit and bring whether it's different or not. You bring on record. Right.
May please your lordship. This is anticipatory bail application. Petitioner number 1 was already granted interim protection. Petitioner number 1 has already appeared. As far as the 2 is concerned, there is no interim protection. Offenses are, my lord, under section 75(2), that is sexual harassment, my lord. That is the only non-bailable.
One who is to.
One is Snigdha Besburwa, my lord. The issue here is, my lord,
One is who? One is how she's got this.
she is the sister of the informant, my lord.
Sister of the informant.
Sister of the informant. The informant and the sister, my lord, they have been feuding over their ancestral property, my lord, after that.
Okay, and who is Paros Pratim?
Paros Pratim Sonwal is the boyfriend of the petitioner number 1, my lord.
Okay, so both of them are coming.
Yes,
Okay, Mr. Saul.
We have received the CD lordship, and as per CD lordship, that the material reveals lordship, that lordship, there are some WhatsApp messages also lordship from the
Regarding what?
say her sister and as well as that her boyfriend also lordship.
Hmm.
That lordship,
Now, ultimately, the allegations are what?
allegation is that they are instigating to have physical relation. The sister, her sister herself has instigating her to make physical relation with her boyfriend. There is some WhatsApp messages also wherein it is stated also if he do not he cannot make physical relation with you, then he may leave me. That part is also there in the WhatsApp message also. So he and even for that purpose.
Let's see the FIR latest.
Page 16, man.
So younger sister is filing the case against
The elder sister.
elder sister and her boyfriend.
And your lordship.
Alleging that like both of them trying to sexually harass her.
Harass her and threaten.
And
Threatening her.
in terms of the aforesaid this thing, yeah, both of you have been granted interim.
Only the sister has been
And
granted.
the sister has been granted interim.
She has appeared. And if your lordship has noticed, my lord, the FIR, she mentions one Priyanshu Shrutikar, my lord. Priyanshu Shrutikar happens to be the boyfriend of this informant, my lord. Now the sisters are feuding over the property left behind by the mother. And because the two boyfriends have also come into the picture, this whole episode has happened. And your lordship has also seen that they have lost multiple, she has also lost multiple FIRs in the past also.
No, that I haven't seen.
My lord, we are in the 3rd paragraph as well as the 5th paragraph of the FIR. 816, my lord. She refers to in 3rd paragraph, my lord. She refers to an incident of 24th August 2025
where the demo police had attended the,
Or where is the FIR?
my lord.
Where is the?
No, she does not mention the FIR. She says that she had approached the police.
But like there is no FIR.
Again, on the same sets of allegation, on the basis of same allegation, earlier that is their lordship. Earlier he lost complaint before the police station, and thereafter he came and he also assured them in written, that is not here, in written, that he will not disturb. So this is the continuation, lordship. This is not the any other separate
Last
FIR,
para
lordship.
also, my lord. Page 16, last paragraph. That boyfriend had lost an affair.
His boyfriend was also assaulted.
Yes, Mr. Locker, what are the materials?
First, lordship, that WhatsApp messages, lordship can see, lordship, 2, 3.
WhatsApp message by whom?
By the his elder sister, lordship, and subsequently from the boyfriend also, lordship. That is, lordship, two messages, lordship. After the witnesses are there, lordship, and the statement of the informant's boyfriend is also there, when he was assaulted earlier by because of all these issues, lordship. She was harassed, lordship.
Both of them together or what? The sisters?
No, probably not, lordship, because
No, she has moved out, my lord. She has moved out with her boyfriend, my lord.
the yellow color flag, lordship, I don't believe.
Parents are dead, my lord, and the whole problem is
The mother is died, no?
mother is dead, my lord. Both are orphans now, my lord.
Allegations are against you, Mr.
My lord, can you see, my lord?
Yes, allegations are against you.
The offences which have been under which the case has been registered, my lord. Talking, my lord, that remains bailable, my lord. Lordship, can you see the sections, my lord? 75 subsection 2.
What is
It is
that?
sexual harassment, my lord. Here, my lord, though this is the only non-bailable section, the punishment only is up to 3 years, my lord. Others are 78 2, my lord. That is bailable, my lord.
Correct.
And the other is 351 2, my lord.
But the 3 years jail is there.
Yes, my lord, it is there. So, my lord, my humble submission is that, my lord, even if there is material to that effect, my lord, offences where the punishment ranges up to 7 years, my lord, in that case, my lord, the option of issuance of a notice to the accused is there. Only when the accused does not cooperate with the investigation, my lord, he is to be taken into custody. So, in this case, my lord, I am ready and willing to cooperate with the investigation. One of the fact remains, my lord, that there is a dispute between the two sisters over the ancestral property, my lord. And earlier also, my lord, cases, complaints were lost, my lord. Something has been ongoing, my lord.
Again, you go and like threaten her.
My lord will impose strict condition, my lord, will refrain from when contacting the sister, my lord.
Saharia. Locker.
But lordship, again, lordship, it is to lordship, but lordship, again, that is the
on strict conditions.
Probability also there, lordship, again, after getting bail, you will be some more powerful that I have got the bail, so now you cannot do anything. That is because they
Offense registered under is only 3 years.
that is true, lordship, but
And see, notice is required. And if notice gives, he'll go and provide this.
But even though Lordship,
It's already there.
even
Already, the only thing is that he's apprehending, that's why he has come.
only
Otherwise also that as part of procedure of BNSS, then you have to give a notice and like in notice that he'll go and appear.
notice is that Lordship, but Lordship that before he is not against that BAB, Lordship, the BA. It is AB only. So Lordship,
Yeah.
it is on the police has already.
Whatever, in case of arrest, we are saying.
Even the Lordship, if he notice is being given, and thereafter if police found that his arrest is required, then also police may arrest him, Lordship.
Correct,
But
that's what I'm
once the
saying.
protection is from this court is given,
Whether the arrest is required or not, that's what I'm asking. But we have noticed if he given, then he goes there, he gives all this information. Otherwise also he'll give the information. If
Lordship,
usually
so section, though allegation is 75 to 3 years, but the
not Mr. S. Thomas, the learned counsel.
which the condition, Lordship, that he should not.
Is applicable. He will not be allowed to contact her any manner. And if he does it, then you can come for consideration. No problem.
That much.
As Mr. S. Nawaz, the learned counsel, referring to the his applicants, also heard Mr. P.S. Lapa, the learned state. Is an application under section 4 of BNSS 2023 for granting clearance bail to the accused applicants in connection with the no case number 37/2026 under section 75 in the 2 78 in the 2 case 51 of BNS 2023. The allegations as narrative in the dated 23 3 FI
My lord.
23 2026. But it was filed before SP.
SP, my lord, subsequently registered on, my lord, 2426. At page 12.
Page 12.
Page 12, my lord.
So we'll go by that.
That, my lord.
Page 12. An FIR was lodged on 242026. 26 alleging that the accused applicants being sister and brother-in-law of the informant had been harassing.
My lord, boyfriend, okay.
Oh, sorry. Sister and her sister's boyfriend had been harassing her for sexual favor. Also, after receipt of the FIR, the police raised, listed the no PS case number so and so. At 27/2026 under the aforementioned section. The coordinate bench of this court by order within 5/5/2026 has granted interim pre-arrest bail to accused petitioner, accused applicant number 1. Accused applicant number 1. Then Mr. S. Nawaz, the learned counsel, hearing for the accused applicant, submits that the only section which is non-bailable is 351.
No, 75.
Sorry, 75 in bracket 2, 75(2) of DNS, whereas the other offenses are non-bailable. Other offenses, other alleged offenses are non-bailable.
Others are bailable. 75.
Sorry, bailable, sorry, bailable. No, 75(2) is non-bailable, others are bailable. 25(2) is non-bailable. Those are bailable offenses. If others submits that in case of, if others submits that, section 75, section 75(2) also the maximum punishment is, maximum punishment is 3 years. 3 years. He submits that looking into the entire factual aspect, which involves certain allegations of in a property inheritance related issues between both the sisters. This court should consider granting bail to the accused, granting pre-arrest bail to the accused applicant number 2 also. It further submits that in terms of the aforesaid, in terms of the earlier interim order, this is 5/5/2026, the accused applicant has already appear
Appear, my lord.
appear before the IO and got her statement record. On the other hand, the learned APP, Mr. P.S. Locker, the learned APP opposes the bail application, stating that there are sufficient materials against both the accused applicants for harassing the informant, harassing the informant. Next part. After hearing the sufficient, CD has come, no?
CD
The CD in the case is already has been submitted for this court. This is used after hearing the submission made by submission made by the council according to the respective parties. This court is responsible that the interim bail so granted. Interim period is bail so granted earlier to accused applicant number 1 should be made absolute. Full stop. It is further it is further is the opinion of this court that the accused number 2 should also be granted the privilege of pre-arrest bail. Full stop. Accordingly, it is direct that in the event of arrest of the accused applicant number 2, he shall be granted he shall be granted bail on furnishing of a bail bond of rupees 30,000 with a security of like nature, subject to the condition that the accused applicant shall appear. The accused applicant number 2 shall appear before the investigating officer within a period of 10 days of passing of this order and shall fully cooperate with the investigation. The interim bail application, the interim bail granted to accused number 5 is hereby made absolute. Then you write, it is made clear that the accused applicant number 2 shall not try to influence any of the witnesses who may be involved in the instant case, and also shall not try to contact or get in touch with the informant in the instant case for whatsoever reasons. In terms of the opposite direction, the instant bail application is disposed of.
Deep levels. The last part, when making the interim bail absolute, perhaps the lordship is accused number 5. Accused number 5.
Accused number 1, I said, no. Accused number 1 and 2, they know 5.
And deep levels.
CD2.
Hey, please, your lordship. Just may I argue the bail application past 43, my lordship, item. 42 is the AB, my lordship. My lordship can be permitted.
2 different persons.
Yes, different because it's common affair, my lordship. Common affair, my lordship. Lordship, the
Bail application, CD, this thing come.
CD come.
Yes, pass.
may submit, my lordship. The informant is the father of the victim and the accused petitioner are in jail. They're the own maternal uncle, my lordship. So FIR is page number 15, my lordship. So may I read the FIR, my lordship? The সন্মানপূর্বক বিনীত নিবেদন এই যে মর্মী পারবেন 13 বছর বয়স সৰু ছোৱালী হয় যোৱা ইংৰাজী 26 তাৰিখে ৰাতি অনুমান 9 মান বজাত মই ঘৰত নগতকা অৱস্থাত নিম্নলিখিত 1 নং পদকীয়াজনে ছোৱালীজনীক ৰাতি অনুমান 9 মান বজাত সিহঁতৰ ঘৰত নি কিছুমান সময় পিছত পুনৰ ঘৰত থৈ যায় পিছদিনাখন 27 তাৰিখে পুৱা অনুমান 4:03 মান বজাত মই ঘৰলৈ ঘূৰি আহি ছোৱালীজনীক অসুস্থ হৈ থকা বুলি গম পাওঁ আৰু পুৱা অনুমান 8 মান বজাত তাইৰ মুখমণ্ডলত আঘাতৰ চিহ্ন আৰু মূৰৰ সোঁফালে গুৰুতৰ জখম দেখা পাওঁ আৰু পদকীয়াজনে মোৰ ছোৱালীজনীৰ মুখমণ্ডলত লাগি থকা তেজসমূহ পানী ঢালি চাফা কৰিব থকা দেখা পাই লগে লগে মই ছোৱালীজনীক লক্ষীপুৰ চিকিৎসালয়লৈ নিব বিচাৰো কিন্তু পদকীয়াজনে ছোৱালীজনীক চিকিৎসালয়ত ভৰ্তি কৰিবলৈ বাধা দি লক্ষীপুৰৰ এখন লেবৰেটৰীত যাব দিয়ে কিন্তু উক্ত দিনা ৰাতি অনুমান 2টা মান বজাত ঘৰতে তাইৰ মৃত্যু হয় মোৰ সন্দেহ হয় যে নিম্নলিখিত পদকীয়াজনে ষড়যন্ত্ৰ কৰি মোৰ ছোৱালীজনীক হত্যা কৰিছে so my lordship my first limb of argument is that in FIR itself it is mentioned that this FIR is lost on the legal suspicion my lord
It always doesn't suspicion.
my lord and second fact is that in this FIR it is mentioned that the accused petitioner they have taken it, but the FIR named accused petitioner is not me, my lordship. The other two person, my lordship. The Samidul Haq, Pita Akbar Ali, and my father name is Fahmuddin Ahmed, my lord.
Sanidul Haq too.
Sanidul Haq is the one maternal uncle of the victim who died, my lordship.
Maternal uncle. of the
One
victim.
maternal uncle, my lordship.
And
And
Samidul Islam, Sanidul Islam, same.
actually, my lordship, here I think some mistake maybe happened because here the name, father name is different.
No, Sanidul, who is, you have,
I'm defending Sanidul alias Samidul.
you have come to this court for whom?
I am come to the court before my lordship.
Sanidul.
Hamidul Islam, son of Saimuddin Mullah, my lord.
Samidul is,
Father card it is mentioned, but Sanidul, father name
Why he has
Saimuddin.
come? If he is not that person, he should not come.
why is,
Why he has come, Lord?
So I arrested myself. Samidul Islam, I am arrested, my lordship.
you have been arrested?
Yes, I am in jail my last 3 days, my lordship.
Huh.
I'm languishing in jail. And second person, Salman Ali, I'm not named in the FIR, my lordship, but I am in languishing in jail last 63 days, my lordship.
But you have come up,
So I'm for Samidul Islam and Suleiman Ali, my lordship.
Samidul Islam and Suleiman Ali.
Yes, my lord.
Suleiman Ali is arrested for what?
For the alleged offense of this.
An accused name has been given in the FIR, two accused names, right?
Yes, my lordship.
Two accused name, they are
Both are brothers, Lordship, and both are maternal uncle, Lordship.
One maternal uncle.
Sanidul Haq.
Sanidul and Suleiman.
In the FIR, whose name is there?
Yes.
Sanidul and Hasna Bhanu.
Yes, my lordship. But here, my lordship may say the Sanidul Haq Pita Akbar Ali. Your lordship,
Wait,
kindly
wait.
see page number 18.
Asking how many people are named in the FIR?
Two people, my lord.
Who are they?
Their name is Sanidul Haq and Hasna Banu, my lord.
Then why are you saying Samidul? How he got implicated, that's what I'm asking.
While I was I was given the last right of my niece. That time, my brother-in-law, that informant, he called the police and they arrested me, lordship. I was arrested on the graveyard, my lordship, while I was performing the final right of.
Samidul Islam and Suleiman Ali.
Yes, my lord.
Correct, these two persons.
Yes, my lord.
They have been arrested ultimately.
Yes, my lord.
What about Hasna Bhanu?
Hasna Banu is not
She's
arrested.
awaiting arrest.
Implicantly, I have filed the AB, my lord.
She is
Defense advance.
yes, she's awaiting arrest.
Yes,
So these two persons,
yes, my
what
lord.
are the materials there?
First, Lordship, regarding Lordship, the incident as per the evidences the I has collected, Lordship, that the Sanidul has asked they are residing nearby.
Never.
Sanidul asked his nephew that Lordship come to my house. Today I'm going to a marriage attend marriage ceremony. So you just be with you. And thereafter they went. The two sisters and the victim. The victim and her sister went there. But subsequently the sister came back, and the victim stayed there in their house. And after some time, that maternal uncle came with that victim and kept her in their house, and he left her home. Thereafter, Lordship, in the midnight, she got
She was feeling not good.
not so good. Thereafter, her mother saw her that the bleeding was coming. There is a bleeding. So thereafter, in the morning, his father father was doing in some work as a labor in Saint Mohan.
Okay, okay, then
So material suggested, Lordship, that postmortem report is there, Lordship. That brain injury is there, Lordship. Head injury is the
sexual offense.
no sexual offense, not Lordship.
No sexual
No,
offense.
but the head injury was there, Lordship.
What
And
could be the motive?
motive, Lordship, probably, Lordship, that because, Lordship, from the evidences that I have seen, some of the witnesses have stated that, Lordship, there is some altercation took place with their husband and wife, Mama and Nami. And in between them, she may be assaulted. And because one of her grandmother, the grandmother of the victim, she, as per her statement, she asked her, who killed you? Then she told that Mama killed me. Mama assaulted me. She told her. So this is the evidence. So, Lordship, regarding the Samidul, there are
63
sufficient.
days, my lord. 63 days.
Samidul, Lordship, there are sufficient materials. But Suleiman and Hasna, I cannot say, because regarding Suleiman is the brother and he was not there. From the evidences also, he was not there. But Samidul, his custodial interrogation is required, Lordship, because, Lordship, some investigation is more required.
And like what about this forwarding report? What is the material about Samidul?
Samidul is, Lordship.
Suleiman.
Suleiman, Lordship, the material reveals, Lordship, he was not there at present at that home. He was later on he came. So Suleiman, regarding Suleiman, I have not found any such.
May I submit something?
Regarding Hasna, lordship will decide lordship because she is the wife.
Actually, what happened, my lordship, here, this particular informant had another wife, my lordship. And the victim's mother and her father,
So whatever happened, your house, something happened because of, she was a,
they live separately, my
wait,
lordship.
wait, she was a healthy child. She went to your house, she came back, she felt something,
Yes, ma'am.
and then later on she died.
Yes,
Now, what has happened, the trial court will decide.
yes, ma'am.
He just need to see the prima facie thing, and he is fairly submitting, APP is fairly submitting that this person was not there, Sulaiman Ali. He's saying that like this person, Samidul Islam, his involvement may be there, prima facie involvement looks like there. That is what he is saying.
Yes, ma'am.
He's not saying anything against you, correct?
Yes, ma'am.
And Samidul, in fact, Sulaiman Ali, I am asking him whether some materials are there or not. Correct? So everything he is doing fairly. So let us go by this, and what more submission you want
Yeah,
to
my
make?
lordship, may I just pray lordship to see the page number 17?
What is there? You tell me.
When the victim's father arrived for the work for near the house first wife, Dhumergarh, the victim.
So
and
you
the-
want, you want a, you want a, this thing, I mean, discharge in this court,
My lordship, my lordship.
huh? Before hearing your matter, before the trial, you should be this thing.
Lordship, kindly consider the length.
You face the trial, I mean, you face the trial, I mean, but as far as Sulaiman is concerned, if there is nothing, then we will grant him bail. Okay. Since you are getting for one person, so, and another person, there is some prima facie involvement. So it's better for you, you argue for the person who deserves bail, rather than arguing for the person who doesn't deserve it. You understood?
Lordship, kindly consider the length of detention, 63 days in the jail, so may not be more than 63 days. So custodial interrogation may not be necessary.
See, I told you once that don't unnecessarily argue. Hmm. Heard, Mr.
Aramin, my lordship.
R. Amin.
Yes, sir.
R. Amin, the learned counsel appearing by accused applicants, also heard Mr. P.S. Crawford, the learned APP for the state. This is an application under section 483 of BNSS. BNSS paying for grant of bail to the accused applicants in connection with Lockheedpool PS case number 48/2026 under section 16 bracket 2 stroke 1023 bracket 1 of BNS 2023. An FIR was lodged on 26/3/2026 at about 9 PM by the informant alleging that his minor daughter went to the house of the accused applicant number 1 about 4:30 PM, and when she came back, she was found to be sick. It was alleged that his minor daughter sustained certain injuries, and there was some traces of cleaning the blood from her face. So, after seeing the aforesaid, the informant wanted to take take his minor girl to the hospital, but the accused persons tried to obstruct him. Rather, advised him to go to some laboratory rather than to the hospital. Realized that on the next at about 2 AM, he found his daughter dead. In view of the aforesaid, he suspected the involvement of the accused applicants, accused and his wife, namely Banu Begum. Hasna Banu, his wife Hasna Banu, and accordingly filed the FIR No. Not file FIR. That's not one of them. Okay, last thing can you? If. Yeah. Wow. Full stop. In terms of the aforesaid FIR, the police registered Lockheedpur PS case number 48/2026 and arrested the two accused, arrested the accused applicants on the same date. Both
229, my lordship.
Huh?
29.
both
Yes, my lord.
on 29/3/2026, and thereafter they are behind the bars. The learned counsel appearing for the petitioner accused applicants submits that the accused applicants are in fact uncles the victim girl, and they were nowhere and they are nowhere linked in the in the offense as narrated in the FIR. He further submits that since the accused applicants have already spent how many days?
63 days.
63 days behind the bars, the accused applicants should be granted bail. Yeah, is that in the instant case has been produced before this court, and the same is perished. The learned APP opposes the bill. Mr. P.S. Locker, the learned APP opposes the bill, care of bail, by submitting that there are materials against the accused applicant number 1 of his involvement. Prima facie material against the accused applicant number 1 of his involvement in the instant involvement in the offense narrated in the FIR. Full stop. However, he fairly submits that from the materials available in case diary, case diary till date, nothing incriminating as such is available against the. Or I'll not write anything. Okay, we cut this line. Cut this line. Last line cuts. Okay. Taking into consideration the materials available in the case diary, as well as the submissions made by the counsel appearing for the respective party, this scope is of the considered opinion that there are sufficient materials against the accused applicant number 1 in the instant case. However, nothing much is available against the accused applicant number 2. In view of the aforesaid, this court is of the opinion that the accused applicant number 2 accused number in view of the aforesaid, it is directed that the accused applicant number 2 shall be released forthwith from jail on submission of a bail bond of rupees 50,000 with a severity of like nature, to the satisfaction of which authority is this?
CGM Golpara, my lord.
CGM Golpara.
Yes, my lord.
CGM Golpara, so the satisfaction of CGM Golpara, subject to the condition that the accused applicant number 2 shall cooperate with the investigation, fully cooperate with the investigation, and shall not try to influence any witness that may be involved in the instant case. Needless to say, the prayer for bail of the accused number 1 is rejected. In terms of the opposite direction, the instant bail application is disposed. Locker, anything else? How many days they have? 66 days?
63 days, my lord.
63 days, 90 days, no?
No, my lord. Yes, my lord.
Okay, accused number 2, we are giving him because there is no material. 1 is rejected.
Yes, my lord.
Now this one,
My lordship, here, just because my learned friend just fairly submitted, nothing material against the husband, my lordship, only
you are
that.
present there.
I will appear, my lordship. The lordship may protect. My being a lady, my lordship, my husband in the jail, my lordship. Because number one is my husband, my lordship. Somebody must be in that emulate. So on humanitarian ground, being a lady, so may I just pray that I will appear. I am not saying that no material is there. I am saying also because one witness is state lordship that there are some he had some altercation between husband and wife, and in between them she may be assaulted. So no material I am not saying. But lordship, when the grandmother asked her who assaulted you, then she
Mama.
told my mama assaulted me. That is that thing. Later, my
Third, Mr. R. Learned Counsel, appearing for the accused. Also heard, uh, uh, also heard, Mr. P.S. Locker, the learned APP for this. Is an application under section of BNSS 2023 for granting disability bail for accused applicant in connection with Lakipur PS case number of the extra 2026. The section 61 in the 15, stroke 103, with the funds of BNS 2023. An affair was lodged on PS 62 by the informant alleging that his minor daughter went to the house of the accused applicant, and when she came back, she was found to be injured. And on the next day, the minor girl was found to be dead. The learned counsel appearing for the accused applicant submits that the accused applicant is not involved anyway in the incident case as she was in fact not present when the minor victim girl went to the house of her and her husband. Full stop. The learned counsel policy admits that she is a lady. She is being a lady, and she will fully cooperate with the investigation in the case. If she is granted the privilege of privilege of bail, is there in the instant case has been received? Mr. P.S. Locker, the learned appearing for the state proposes the bail application. This court has come to the case diary and having purposes respect that no such implementing material is available against the accused applicant in the instant case. This is a case fit for granting pre-arrest bail. In view of that, it is directed in the event of arrest the accused applicant in connection with PS case number. Connection with Lakipur PS case number 48/2026. She shall be released from bail on submission of the bond of rupees 5,000 to the same the satisfaction of the arresting authority subject to conditions. The accused applicant shall appear before the investigation within a period of 10 days of passing of the instant. Next to the accused applicants will be as a when called. The accused applicant shall not try any witness or evidence that may be involved in the instant case. In terms of the applicant direction, the instant application is displayed.
What you have CD not received, lordship? CD you have not received.
Did you not receive, madam? Heard MS Angora, the learned counsel, appearing for the accused applicant. Also heard Mr. P.S. Locker, the learned deputy for the CD. CD in the instant case is yet to be received. Automatically listed on
12.
Huh?
12 from
12. 12.
Barabar.
Right, please. My lord, this is PRS bill application, my lord. The allegation is that 19 numbers of cattle are missing from Goshala Karan, it comes to know that caretaker of the Goshala, as per direction of the owner, sold it to MD Sulaiman Ali. Finally, the investigation agency arrested both the owner of the Goshala and Sulaiman Ali. I am the friend of accused Sulaiman Ali.
You are?
My lord, I am the friend of accused Sulaiman Ali, who purchased those cattle from the owner of the Goshala, namely Yaqub Ali. My lord. Now, my lord, I will appear before the investigation agency.
Gosala is owned by whom?
Yaqub Ali.
Where?
Sold it to MD Sulaiman.
Oh, where is this Gosala located?
My lord, Northeast Frontier, my lord, Jalukbari, at Jalukbari, my lord, Northeast Frontier Goshala.
So owned by
One Yaqub Ali. Yaqub Ali.
Gosala is Yaqub Ali.
My lord.
He has sold it to
Sulaiman Ali.
Sulaiman Ali. And Sulaiman Ali sold it to Zakir Hussain.
No,
No,
not Solomon
I am
Ali.
friend of Sulaiman Ali.
Huh?
Yes, this is his statement, Lordship, but as CD is something different, Lordship.
That is what?
That as per CD, Lordship, that person, the owner, used to sell it regularly through Suleiman and Zakir, both, Lordship. On the day itself, Lordship, what happened, Lordship, that in the morning time, the caretaker of that person, Gosala, he went to lodge an FIR that human numbers of cattle were missing because that is their plane, actually. Then when police interrogated them, then it reveals that he told, subsequently he told,
He himself sold it.
he admitted,
himself-
yesterday night when the owner,
Where is it?
No, my lord, I am the friend of Sulaiman Ali.
he was also present there, Lordship, at the time.
Maybe I am the friend. He called me to.
Okay.
My lord,
He's a regular purchaser. Gosala, this is not their own property. This is the Gosala
my
where
lord,
cow
the
cattle were
allegation of
kept.
theft will not come, my lord.
Hmm?
Allegation of theft will not come.
What?
As the allegation of theft will not come, as because the owner of the Goshala himself sold those.
No,
cattle.
that is not his property, Lordship. The owner, cows are not his property, Lordship.
I am not on this. As because with the knowledge of the owner, my lord.
But you have bought certain property illegally.
No, my lord, I am on good faith, my lord.
You are good
They
faith.
did not disclose that those properties
you are
not
not
related to
aware.
me. My lord, Yaqub Ali sold it to the Sulaiman Ali.
You are so innocent.
No, my lord.
Mr. Zakir Hussain. You are so innocent.
I came with my
You
my lord.
do not know
I came with
from where cattle are supposed to be bought. Gosala sales in any Gosala
cannot
sales.
sell, my lord.
Then,
But Yaqub Ali sell it to Sulaiman.
then
I am being a friend. I
no.
came with my lord.
see, any Gosala sales cattle will tell you.
So my lord, basic fact has been recovered, my lord. So my
The
lord,
recovery, the-
my lord, whether my custodial detention is required, my lord, I will cope.
there is
At
a-
any strict condition, my lord. At any condition, my lord. For the remaining investigation, I will cooperate with the investigation as well.
you
As because all the offences are
heard Mr.
up to 7 years, my lord.
Heard Mr. So and so, the learned counsel, and also heard Mr. P.S. Doctor, the police arrested. There is an application under section 482 of BNS 2023. Granting for clearance bail to the accused applicant in connection with Jalukbari PS case number 926 under section 112 in the people stroke 303, the 15 stroke 317 stroke 61 of BNS 2023. An FIR was lodged by one Moinuddin Sheikh before the Jalukbari police station, alleging that Moinuddin is the Gosala owner.
My lord.
Yeah,
is the caretaker, my lord.
That he is the caretaker of the Gosala. Gosala is owned or is managed or what?
It is his own.
He's the caretaker of the Gosala owned by one Yaqub Ali. Yaqub Ali. Then you write semicolon, then that two persons, namely Suleiman Ali and Jakir Ali, both are residents of Bautala, came to the Kosala and stayed there for some time. That both of them came again, stayed with the Kosala, and on the next morning, he found that 19 cows were missing. On receipt of the FIR, the police raised the information. The police raised the Javed Bari case number. Case number 94/2026. On investigation, police found that in fact the cows, the missing cattle were sold by the owner of the Kosala, namely Yaqub Ali, to the aforesaid Suleiman Ali and his friend Jakir Ali. It is also Jakir Ali. The case that in the instant case has been dismissed and sentenced produced. The learned counsel, according to the accused appearance, submits that the accused applicant is the friend of Mrs. Solomon Ali, and as he came from Bogota meeting, he was also there. He was also there with the aforesaid Suleiman Ali. Submits that he is nowhere linked to the aforesaid selling or buying of any cattle. This court has gone through the case diary by present produced in this court, and after having found sufficient implementing material against the accused applicant, the litigant is not willing to grant any privilege of pre-arrest bail to the accused applicant. Accordingly, the same is rejected.
Not a report was called for lawsuit, that the apprehension that some FR might have been lost against him in the for petitioner. And for that reason, an inquiry report was sought.
The report has been received, Lordship. No case till date has been registered. Only an inquiry was going on.
Only?
An inquiry was done, Lordship.
So where is the apprehension?
Which the
So Lordship, police has been visiting Lordship and no notice were issued, Lordship, nothing.
Notice will be issued. I mean, only on the basis of inquiry, you come and like file this.
Till then, Lordship, I'll appear in the inquiry, Lordship. That
You do one thing, you either withdraw this or I'll dismiss this. There is no apprehension. Without any apprehension, you all come.
that order may be possible. That order may be possible.
What order?
That no apprehension is there, Lordship.
Based on the report, Lordship, it is stated, Lordship, no case is pending. That
Who is Taifur Rahman?
present petition.
Present petition.
Present petitioner. What has happened, Lordship, the informant, he took some money from the present petitioner on loan. And in lieu of that, he submitted 3 checks. Now, it is the case of the informant, Lordship, that he had already repaid the money to him by bank transfer and by money transfer, Lordship. He has repaid. Thereafter, Lordship, what he is doing now, Lordship, is that he is threatening him that he will use those checks. Otherwise, you pay some amount, and he is threatening him. Thereafter, he approached the concerned police, Lordship, and the police, after after seeing the bank transfer, they were convinced, Lordship, and thereafter they made an inquiry. So Lordship, no FIR has been lodged as of now, Lordship. That is the situation.
Because
Yes. Just an inquiry was done.
sit back and this thing.
Yes, then, Lordship, dismissal saying that, Lordship, as per the instruction.
Hmm?
As per the instruction, Lordship.
Okay, heard Mr. S. Munir, the learned counsel, appearing for the accused applicant. Also heard Mr. B. Sharma, the learned ATP for the state. This is an application under section 482 BNSS, paying for that player is going to the accused applicant, who is in apprehension of arrest in connection with the case that may be raised against him under Article of registration. Also, this a coordinate bench of this court by order dated 25/5/2026 26 to 6 directed directed for submission of a detailed report from the officer in Satrika police station as to whether any case has been raised against the present use of the full stop. Today, when the matter was taken up, the learned APP, Mr. B. Sharma, the learned APP, has submitted a report dated report dated 35/2026.
Lordship, as the inquiry has been going on, Lordship, I was called to APR, Lordship. My only apprehension is that, Lordship, that one line may be repeated, I may cooperate with the investigation.
You see, I mean, a report is that you have been asked to appear, but you are not cooperative. You go and appear.
No, only apprehension was that it has been, because police is not disclosing the fact, Lordship, what they have disclosed now, Lordship. That was not disclosed.
See, like, I mean, yeah, specifically it has been stated that you neither reported or nor communicated with.
No, because Lordship, nothing was disclosed by the police, Lordship. That was my.
You go to the police station, find out what is there.
No, they are not disclosing, Lordship. That is the problem. They went to my place also.
At this
Lordship.
time, I don't think there is any apprehension. All the cases, Mr. Munir, you are a counsel. You have been appearing in so many cases in bail. You know about this. I mean, when there is no apprehension, how can this court can interfere? You know about this. Mr. B. Sharma has submitted a detailed report. Before this court, which reveals that no FIR has been filed against the accused applicant in the till date. The aforesaid report is marked, the aforesaid report dated 5/2026. It is marked X, is kept on record marking X. Nothing X. In view of the aforesaid report and taking into account that no FIR has been filed against the accused applicant as yet, this court is of the considered view that there is no such apprehension of filing the instant anticipatory bail application before this court by the accused applicant. So accordingly, the instant bail application is dismissed.
Lordship, much obliged, Your Lordship. Much obliged.
Lordship, in that case, there was an interim, if I'm not wrong.
So interim orders first orders. So
Here also,
stands
Lordship,
vacant.
yes, here also that report was called for, Lordship. No case is registered against him.
The same order, same order.
Here, Lordship,
Yeah,
there was no
okay.
interim.
Heard Mr. M. Hope, learned counsel for the applicant. So heard Mr. B. Sharma, learned APB for the state. The instant PB application has been filed. Instant application has been filed under section 482 of BNSS 2023. Paying for granting PRS bail. PRS bail for the accused applicant who is apprehending arrest in a probable case that may be lodged against the accused applicant in Gauhati police station by one after other. This a coordinate bench of this court by the order of 26/5/2026 has directed the officer in charge Gauhati police station to submit a report whether any criminal case has been registered against the petitioner, accused applicant, namely journal of the in terms of direction. A WP message dated 25/2026 has been sent by the concerned officer in charge to the learning to the office of the learning PP PP which has been produced by the learned PP before this court. The WPS is the person that witnesses reveals that no case or no FIR and or any criminal case has been raised against the accused in the incident case. You want to withdraw or dismiss?
Kindly there, my lord.
No, we'll dispose of.
Kindly dispose of my lord. Kindly dispose of my lord. Instead of dismissing my lord.
No, we'll have to dismiss it.
Kindly dispose of my lord.
Since there is, no, then we like, the aforesaid report is kept on record by marking X. Taking into account the aforesaid report, which reveals that no case has been filed, no case has been filed against that case. This court is that there is no evidence of any arrest for the accused applicant to this case. Accordingly, the instant the PPC is dismissed.